Guys, we're going to get started. So welcome to the 2022 Battle of the Experts Championship trial. We've got an excellent round for the people that are watching here and the people that are watching live on YouTube. We're really excited to get going. Before we get into the trial, I just want to briefly introduce our excellent scoring panel, starting with two of my colleagues from Plaintiff sitting on the right here. I'm going to introduce them together because they have very similar background. Aaron Dunbar and Lorraine Donnelly are attorneys at Plaintiff Spector, which is a plaintiff's injury law firm just down the street here. Together, they've tried to combine over 100 trials. They've recovered millions of dollars in settlements for the clients. Before this, they were both civil defense attorneys, and both assistant district attorneys in Philadelphia. Variety experience, including trial experience, and people are really excited to have. Matt Leckman is the founder of Leckman Law, which is a nationally recognized plaintiff's injury firm in Philadelphia as well. His verdicts have exceeded $100 million combined. He's had a lot of very big verdicts for catastrophically injured plaintiffs. Matt also coached the Dress Line trial team for a number of years, where his teams earned national success at the competition hosted by him. He was also a regional host of the SAC AAA competition in Philadelphia for many years, and we're really excited to have Matt. Clancy Boylan is the managing attorney of the Philadelphia office of Morgan & Morgan. Of course, what's went on screen because my group club is here. A nationally recognized plaintiff's personal injury firm in Philadelphia as well. He's also recovered millions of dollars in settlements and trial verdicts for his clients. He was also a coach for Drexel's client's trial team. Most recently, in 2018, Clancy's team won the Capital City Challenge hosted by Americans Law School. And as a law school competitor for Duquesne, Clancy was selected to compete at the top, which is the competition that recognizes the state trial advocates every year. We're really excited to have Clancy. Veronica Finkelstein, Assistant United States Attorney for the Eastern District of Pennsylvania in the Civil Division. She's taught trial advocacy at several national organizations, including NITA. And Veronica is a faculty advisor to Drexel Klein's moot court team. We're very excited to have Veronica once again. She's a judge at Battle of the Experts. And last but certainly not least, I'm going to take us to the side here to introduce our presiding judge, Jim Waldenberger, who's a partner at Klein Inspector. Jim is an adjunct professor at the Klein School where he teaches introduction to trial advocacy. Jim was also a coach for Drexel Klein trial team, most recently in 2019. Jim's AAJ team was a national quarterfinal at AAJ national competition. Jim has also recovered millions of dollars in settlements and trial verdicts for his clients at Klein Inspector. And most importantly, Jim is one of the couple of best lawyers I know. And so we're really excited to have Jim in the trial. With that, I'm going to turn it over to the presiding judge, Jim. Good luck, guys.
Thank you. Good morning. My name is Sydney Gaskins. Today, I represent the plaintiff, the estate of Grace Topping. I'm joined by my co-counsel today.
Good morning, Your Honor. Peter Jones for the plaintiff.
Thank you, Mr. Jones.
Good morning, Your Honor. My name is Anna Padron, spelled ANNAPADRON.
Good morning, Your Honor. My name is Cami Giacomo. That's spelled CAMI. Last name DIGIACOMO.
Thank you very much. Both sides can be seated. So do we have any pre-trial matters to discuss before we get this going?
Yes, Your Honor, we have a couple. First, do we have your permission to move freely about the trial during opening statements, examinations, and closing arguments?
Absolutely.
Also, Your Honor, in this jurisdiction, we can't approach the bench for objections, so we just ask that our objections are constructively heard outside the jury.
Fine by me.
Your Honor, would like to draw your attention to the pretrial order in this case, specifically pretrial order 13.
Have it in a moment. Okay, got it.
The parties may not. The speed of the ride is not a part of the product at issue in this case, Hyder's wrath. The court finds that the speed of Hyder's wrath is part of the product and can be a defect as a matter of law. With that, Your Honor, we're doing housekeeping, and we have one.
Any housekeeping matters to discuss?
Yes, Your Honor. The defense had raised two affirmative defenses in their answer. The defense of the risk and comparative negligence. This time, we will be dropping the defense of the risk, and we will still be pursuing our affirmative defense of comparative negligence, as there is evidence that Topping contributed to her own death by releasing her last.
Understood. Thank you. for letting-
Your Honor, we would also like the court to take notice that this is a blockade case. We ask opposing counsel not mention anything to the extent of loss or damage.
You're not going to do that, right?
No, Your Honor.
I think we're okay.
Your Honor, at this time, we would also like to invoke the rule of 615 and have all the witnesses, which in this case is only the plaintiff's lawyer, Alice Driscoll, sequestered.
Any objection?
No, Your Honor, as long as our expert can stay in the courtroom today.
Do you have an objection to that?
No, Your Honor.
They're starting off well. All right.
Also ask if Your Honor would like a formal tender of the experts, and if you would like that formal tender be inside or outside the presence of the jury.
Formal, yes. The presence of the jury is okay.
And at this, we have a few sensitive motions whenever Your Honor is ready to hear them.
Sure. Does have any moments?
We did, Your Honor, but we conferred with opposing counsel before trial and actually reached a few stipulations. We agreed to the admissibility of 4 exhibits in this case. Exhibits 4, 8.
Oh, let me catch up.
Your Honor, I can approach with copies if you'd like.
That'd be excellent. Thank you.
Here you go.
So these are the stiffed exhibits?
Yes, Your Honor.
Great. So as far as the plan is concerned, no pretrial motions, you're good to go.
But Your Honor, we also agreed with opposing counsel that we're okay to use exhibits during opening statements.
Great.
With that, we're ready for trial.
Thank you, sir. You have some motions.
We do, Your Honor. Defense moves for a pretrial ruling on the admissibility of Exhibit 13, which is an exchange of text messages between Ms. Topping and her friend Alice Driscoll. May I approach the court with a copy?
Yes, you may. Thank you.
Your Honor, putting this exhibit with a bit of context, the Toppings have brought this case against Evan Roth after their daughter fell off of one of their rides, Hydra's wrath. The defense is pursuing an affirmative defense today of comparative negligence, as there is evidence today that will see Ms. Topping may have contributed to her lack of that day. These messages are directly relevant in establishing that affirmative defense. Your Honor, looking at these messages and taking them in 2 parts. The messages on the gray you'll find were from Alice Driscoll, a witness who testified today. And we do concede that these messages don't have any hearsay exceptions. And so happy with redacting these messages as we don't believe they're admissible today. But these messages on the blue side, Your Honor, we do believe are admissible hearsay. And therefore we ask for the court to admit them pre-trial.
Your Honor, so long as those gray text messages from Alice Driscoll are redacted, we have no objection.
Like we have an agreement. All good.
And with that, Your Honor, the defense is ready to proceed to openings.
Thank you very much. Plaintiff, prepared to open.
Certainly, Your Honor.
Mr. Jones, whenever you're ready.
When they made it fast, they made it fatal. It's early morning inside an amusement park. All the lights are off. The rides are still. The park hasn't opened. A man is standing at a control panel. Park's roller coaster. turns on the power, flips on the lights, and reaches to set the speed. He's done it 1,000 times. Every time, he sets that speed. 35 miles per hour. But this time, he has new instructions, straight from the boss. 36, 37, 38, 39, 40, just stop. That speed reads 50. Just hours. The park opens and passengers get on that roller coaster at that new speed. A girl's lap bar pops open. She falls 150 feet. Cracks her head on the ground. The evidence will show that those lap bars that kept people in place on the roller coaster, they were designed to handle a maximum speed of 45 miles per hour. The evidence will show that the very first day that the defendant, Dragon World theme park, ran its roller coaster faster than that maximum speed, a lap bar failed. The evidence will show that when they made it faster, they made it fail. That girl was Grace Topic. She was 17 years old. She went to the defendant's theme park on a high school field trip. And she never came home. That's why parents have sued the defendant for wrongful death. We have the burden of proof. We're going to prove, more likely than not, that the design defect in defendant's roller coaster caused Grace Topic's death. We're going to meet our burden today by proving 3 simple facts. The lap bars were designed to handle a maximum speed. The defendant ran that, and that speed killed Grace Topic. So let's take those one at a time. Starting with the first fact that we're going to prove today, those lap bars were designed to handle a maximum speed. You're going to learn from the defendant's engineer, the man who designed the roller coaster, that those lap bars were designed to handle a maximum speed of 45 miles per hour. An expert witness is going to say, and she'll tell you just how important that maximum speed is. She'll testify that if you push a roller coaster just a few miles faster than the maximum speed its lap bars are designed to handle, then those lap bars are going to fail. Which brings me to the second fact that we're going to prove today. The defendant ran its roller coaster fast. It's June of 2020, and the defendant's CEO has a new idea. Let's bump the speed up. He writes an email to his engineer. His engineer emails him back. You're going to get a chance to see him. Hey, boss, not sure about that. The roller coaster wasn't designed for 50. I don't know if the lap bars can handle 50. The CEO tells him to do it. The third fact that we're going to prove today, that new speed killed Grace Topic. You learn the defendant ran its roller coaster thousands of times under at maximum speed, under 45 miles per hour. The day they ran their roller coaster faster than that maximum speed, an eyewitness will tell you what happened. Ellis Driscoll is Grace Topping's best friend. She was sitting right next to Grace Topping on that roller coaster. And she'll testify. When the roller coaster went upside down, she saw her friend plummet 150 feet. And she'll testify that her lap bar was open. Now, after this happened, the defendant claimed this was Grace Topping's fault. Said that she pushed an emergency release bar when she was upside down, 150 feet in the air. And a few days later, it's true she sent a text message to a friend saying, imagine how scary it would be if you push that button. But members of the jury, there will not be any evidence today that she actually did that. Not a single witness is going to take this stand and tell you that they saw Grace Topping push that button. No one will testify that they saw Grace Topping reach for that button. Not a single witness. Not our witnesses, not their witnesses. No one will even testify that they saw Grace turn in her seat towards the button. Members of the jury, the most important facts in today's case going to be undisputed. Undisputed. The only thing keeping Grace from falling to her death was the defendant's lap bar. Undisputed that those lap bars were designed to handle a maximum speed of 45 miles per hour. Undisputed, at the very first day, the defendant ran its roller coaster faster than that maximum speed. Grace Topping died. In today's trial, my co-counsel, yes, is going to ask that you find the defendant liable for Grace Topping's wrongful death. Because when they made it faster, they made it fatal. Thank you.
Thank you, Mr. Jones. Defense wish to open?
Yes, Your Honor. Before they made it faster, they made sure that this ride was not defective. It's June 2020, a month before Dracula opened after the pandemic. Their engineer gets into the same ride Plaintiff just told you about. He sits down in one of the seats. The lap restraint is locked over his lap. The ride operator goes and turns the speed 50 miles an hour. He rides the roller coaster 4 times in a row. First test run, no issue. Second test run, no issue. Third test run, no issue. Fourth test run, no issue. Under the jury, the plaintiff just told you that it was that speed, 50 miles an hour, made its ride defective. But what the evidence will show is that this ride was never effective at all. What happened on July 6th is absolutely heart-wrenching. We do not discount or minimize the pain Toppings must be feeling. But their loss does not mean that our ride was defective. And today, you'll know why. Because this case comes down to three things. Before Dragon World made the decision to increase the speed of Hydra's Wrath to 50, they consulted with their engineer. They ran tests and got consistent results. And they were in compliance with industry standards and regulations. Consultation, consistent test results, and compliance. Those three things are how you will know that this ride is not effective. Let's start with consultation. This decision to increase the speed was not spontaneous. You will meet CEO of Dragon World today, and you will learn that she did not order anyone to increase the speed. She went to her engineer with an idea, and it was just that, an idea. A month early, a month before the park had even reopened from the pandemic. And right from the start, Dragon World's engineer was determined to make sure that this ride was safe, to make sure that the ride would be comfortable for riders at 50 miles an hour. She consulted him. That's how they began. The next step, testing. Now, members of the jury, I want to make sure that we have this clear. The plaintiff was talking about this massive 15-mile-an-hour increase, but what they didn't quite emphasize as much is that this ride was built and tested at 45 miles an hour. So when Dragon World made the decision to run it at 50, it was only 5 miles an hour more than what the ride was built and tested at from the start. But what did they do anyways? They ran tests and got consistent test results. But those are going to be the only tests that you hear about today. So what you will learn is that after July 6th, the plaintiff's engineer and the defense's engineer, they went and they took a look at this ride. And the two of these engineers, you'll learn that they came to the same conclusion. Nothing was mechanically wrong with the restraint system. I said that right. No broken lap bar, no leaky hydraulic, not even wear and tear. Nothing was mechanically wrong with the restraint system. And you won't just have to take my word for it. These engineers, they ran tests, 10 tests at 50 miles an hour. Each test, the same consistent result. Lap bars didn't malfunction then either. The plaintiffs, they brought the case here today. And as they told you, it is their burden to prove that this ride was defective. But members of the jury, their theory is just that, a theory, because you will not see any physical evidence of a defect here today. Evidence you will see, compliance. Dragon World's compliance with industry standards and regulations. And these industry standards, they weren't drafted by the defense, plaintiff. They don't favor either side. They're neutral. And that's important because these regulations are in place to keep people safe. Now, you're going to hear from our expert today. She's going to explain these industry standards and regulations to you. She's going to explain how we know Dragon World was always in compliance with them. You're going to hear a lot today about the restraint system on Hydra's Wrath. But what you'll learn is that there's no specific regulation that dictates the kind of restraint a ride has to have. Talked about this massive speed increase. But what you'll come to learn that there's no regulation that prohibits speed increases or even requires operators to report them. Her engineer is going to tell you how Dragon World was in compliance with these industry standards and regulations. And today you're going to see certificate of inspection. And on this certificate, you won't see any speed. You won't see 35 or 45. And nowhere on the certificate you see anything that says Dragon World could not run this ride at 50 miles an hour. So how did this not bar come in? Our expert is taking an explanation for that. And hard as it will be to hear, that explanation will have nothing to do with what the plaintiffs claim is a defect. That explanation, a manual restraint release button, a button on the side of ride cars, a button required industry standards, a button that you will learn Miss Topping knew about, a button she texted her friend about. She texted her friend saying that pressing this button would make the ride so much scarier. And you will learn she sent that text only 5 days before she went to Dragon World on July 6th. Now, members of the jury, the evidence in this case is going to be hard to hear, but we ask that you look at it critically. At the end of trial, you will know this ride was never defective because this case comes down to 3 things. Before Dragon World made this ride faster, they made sure that it was not defective. They consulted with their engineer. They ran tests and got consistent test results. And they were in compliance with industry standards and regulations. Those 3 things are how people know that this ride was never defective. Find Dragon World not.
Thank you, Ms. Pedro. Plaintiff, you wish to call your first witness.
Yes, Your Honor. At this time, we call Miss Ellis Driscoll to the stand.
Ms. Driscoll, please take the stand.
Do I have permission to set up a visual in the lobby?
Absolutely. And all counsel going forward in terms of your presentations, you don't need to ask for permission to set up an easel, to walk in the well, or approach me or approach the witness. Just have at it.
Yes, Your Honor.
Your Honor, do we need to ask permission to publish what's already in evidence to the members of the jury?
So long as you're confident that your opposing counsel doesn't have an objection to it, I'm completely fine with you just rolling with it.
Morning. Could
Good
you,
morning.
could you please introduce yourself to the members of the jury?
Good morning. My name is Ellis Driscoll,
What do you do for a living?
student here at Drexel University. I'm a pre-law major.
Did you know Grace Topp?
I did. She was my best friend.
Your Honor, may I approach the witness with already in evidence as Exhibit 4?
Yes.
Thank you.
Ma'am, when's the last time you saw your best
The day she died at Dragon World.
You remember what date that was?
It was July 6th, 2020.
Were you with her when she died?
I was sitting right next to her.
How did she die?
We went to Dragon World for a class trip and we're on the ride, we're increasing the speed for it. And about seconds of the ride, she fell.
Let's talk about the defendant's ride. I want the members of the jury to get a chance to see it. I'm publishing what's already in evidence as exhibit. Have you ever rode the defendant's ride before?
Yeah, a bunch of times,
How many times does this ride go upside down?
at least 4.
When you're upside down, the defendant's ride, what keeps you in place?
There's the lap bar that goes onto our waist to keep us in place.
Let's take a look at that lap bar. I'm publishing what's already in evidence as exhibit 11. Do you see that lap bar in this picture?
I do.
What does it look like?
It's that red and orange thing that's in the picture.
This has identified the orange things as lap bars. What were you and Miss Topping sitting in this car?
We were in the back row. I was on the left and she was on the right.
Could you walk us through what happened from the moment the ride started?
Yeah. We got on the ride. We were so excited to try the new speed. The ride started about 20 to 30 seconds into the ride. I heard a thump. So I looked next to me and I saw that she wasn't there. She had fallen out.
What position was the ride in when Miss Topping fell out?
It was upside down.
Did her lap bar look like it does this picture?
It
What position Miss Topping's lap bar in?
was not like it is in that picture.
Would you be able to show the members of the jury where Miss Topping fell out?
I would.
Republishing exhibit 8. Can the witness still want to make use of the visual?
Yes.
Ms. Driscoll, could you point on this diagram to where your friend fell out of the ride? Let the record reflect the witness has pointed to the rightmost upside down boot as where the stick fell out.
No.
Retake the beat now. Mr. Driscoll, I want to address the button on the step of the car that you was Topping or sitting. Did you speak to the police about this case?
I did that same day.
Were you asked if Miss Topping knew about the button on the side of that car?
I was.
What did you tell the police?
I told them that I didn't know about that and Grace didn't either.
Was that the truth?
No, it wasn't.
What was the truth?
We knew about that button.
How do you know that Miss Topping knew about that button?
We talked about it in some text messages.
After you talked about that button in the text messages with Miss Topping, Miss Topping ever talked to you about that button within?
No, never.
On July 6th, when you were on the ride with Miss Topping, did you see her press that button?
No, did not.
Did you see her reach towards that button?
No, ma'am.
Before Miss Topping fell out, did you see her turn towards that button?
No, ma'am.
Let's talk about how Miss Topping fell out. You said you rode the ride before. When you rode the Hydros ride before, did you ever see a lap bar come up during the ride?
No, ma'am.
Between times when you rode the ride before and July 6th, did anything feel different?
Yeah, it felt faster.
I'm sure the Brooklyn Council was been pre-marked for identification as Exhibit 6. May I have a witness?
Yes,
Would Your Honor like a courtesy copy?
yes, please.
May I have it?
Yes,
Thank you.
thank you.
What are we looking at here?
It's an Instagram post that Dragon posted about the change of speed.
Have you seen this Instagram post before today?
I
Also,
Grace did me one night when she was at my house.
fair and accurate copy of the Instagram post that was top will show you.
That, yes, it is.
Plaintiff offers Exhibit 6 into evidence.
The objection?
No, Your Honor.
Admitted.
Permission to publish.
Yes.
Why did the defendant make this post on Instagram?
It was about before we went to the park on June 5th.
What ride is this post?
It's about the ride that we rode, Hydros Raft.
Could you read the top of this advertisement for the members of the jury?
It says new top speed.
How fast does it say the defendant was going to meet their ride?
50 miles.
Thank you, Ms. Driscoll. I have nothing further.
Thank you, Ms. Gaskins.
May I purchase Ms. Richard the evidence?
Yes, you may. Cross-examine.
I'm publishing for an Exhibit 6. Can I inquire?
Yes, you may.
I want to start with something that I mentioned from direct examination.
Okay.
You and Ms. Hopping, you texted about
Yes, we did.
permission to approach the witness with as an evidence as Exhibit 13.
Yes.
Permission to publish to the jury.
Yes.
Way to hand it out. Right, Ms. Driscoll, I want to walk through these messages, starting with the third message from the top.
Okay.
On July 1st, you and Ms. had this conversation, correct?
We did, yes.
And the third message says, did you know there are buttons on the side to undo the seatbelt? I read that correctly?
That's what she said, yeah.
And then I want to direct your attention to the last lead message.
Okay,
That message was from Grace,
it was.
and she texted you. Imagine if you pushed the button on Hydra, the belt went up. It made the ride so much scarier. ... Then a symbol for eyes.
Yes, that's awesome.
Right, Ms. Driscoll, you can go ahead and further text messages. Let's move to when you and Mr. Hopping rode Hydrosoft.
Okay,
You testified under breath, you guys were sitting in the back row.
we were, yes.
You were on the left
That's right.
and Grace was on the right.
Yes,
The ride operator went over to you guys
he did, yes.
and he pushed your lap bar down.
Yes, mine and Grace's.
And Grace's looked like yours did.
When it was down,
Yes,
Yeah, it was the ride operator put both bars down to our waist.
there's another handlebar. When you're sitting, it's a black handlebar.
Yeah, it's the whole one.
It's to hold on to, and you were holding on to it.
I was, I'm for roller coasters.
Yes, but Grace wasn't so afraid.
No, she-
Objection to speculation.
Response to that objection?
Here, this is one of Miss Topping's good friends. She knows Miss Topping well and rollers, whether she was scared or not, because she was right next to Miss Topping on July 6th.
Well, the way you raised the question, you were asking her what somebody else was feeling. I think there's a way to get at that without asking it in that fashion. So I'm going to sustain the objection, but the subject matter can certainly be explored in another fashion.
Your Honor. Now, you to the black handlebar,
I guess
but Miss Topping was not on.
I didn't see her, hold on, no.
When the ride started, you weren't facing Miss Topping.
I was facing forward, roller coaster.
You didn't see where her hands were.
No, I wasn't paying attention to her, I was looking at the roller coaster.
Now I want to move to after Miss Topping fell from Mike's trap.
Okay,
You spoke to the police.
I did.
Police asked you about the same button that you and Miss Topping were texting about.
They did, yes,
They asked you if you knew about this button,
yes, they did.
and you told them that you didn't know.
Yes, that's what I said. No, it wasn't.
They asked you if Grace knew about this button,
They did.
and you told them that Grace,
Yes, I did say that.
and that wasn't true.
It wasn't.
You told them that she didn't have the button because you didn't want her to be blamed.
Yeah, I mean, she wanted to go to medical school. That was her dream. I didn't want her to be blamed.
Want her to be blamed for what happened on July 6th.
Yes, that's right.
Want to confirm?
Sure.
Further question, Your Honor. May I collect exhibits from the witness?
Yes, you may. Any redirect, Ms. Gaskins?
Yes, Your Honor, I do ask that we text messages with Ms. Driscoll for the moment.
Perfectly fine.
A moment ago, opposing counsel asked you about how Ms. Topping said, imagine if you press the button.
Yes.
In these text messages, does Ms. Topping ever say, I'm going to press the button?
No, she just says imagine.
Thank you.
Recross?
No, Your Honor. I just asked to get the exhibits from the jury.
Go for it.
May I approach the witness?
Yes, you may. You're excused. Thank you. Plaintiff, any more witnesses?
Yes, Your Honor. Before we move to our next witness, we'd like to read a portion of Exhibit 20 onto the record. It's a deposition of the defendant's engineer. Pursuant to stipulation 6, they are unavailable for trial.
Have you cleared with the defense what portion you're planning to read in evidence?
Yes, Your Honor, and I'll read out the portion ahead of time so they have a moment to find it in their own copy.
And there was no objection to what he wants to read.
There isn't, Your Honor.
Great. Go for it.
Page 1, line 4 through 7. Question: can you state your name for the record? Answer: Jared Heckler. Question: what do you do for a living? Answer: I'm the head of engineering at Dragonlight. Now looking at page 3, lines 53 through 56. Question: were the hydraulics designed with a speed of 50 miles per hour in mind? Answer: they were designed to handle speeds up to 45 miles per hour. Can we call our next witness?
Yes, you may.
Plaintiff calls Ms. Samantha Wax to the stand.
Ms. Wax?
May I proceed?
Yes, you may.
Good morning. Could you please introduce yourself to the members of the jury?
Good morning. My name is Sam Wax.
What do you do for a living, Ms. Wax?
I'm a mechanical engineer with a specialization in roller coaster safety.
How are you involved in today's case?
I was asked to assess the design of the defendant's roller coaster and determine what exactly caused Grace Topping's lap bar to open on July 6, 2020.
Well, before we get to your conclusions, I want to give the jury a sense of your qualifications. What degree do you hold?
I have a bachelor's of science in mechanical engineering from UCLA.
Do you have any professional experience with roller coasters?
Absolutely. I've been in the industry for almost 20 years. I designed roller coasters for Disneyland, Disney World, and Everland Amusement Park. I'm currently the president of Everland Amusement Park here in Pennsylvania.
You said that you've designed roller coasters. How many roller coasters have you designed?
I've designed 14 for Disney and 2 for Everland.
Are you certified to inspect roller coasters?
Absolutely. I'm certified in the state of Florida and here in the Commonwealth of Pennsylvania.
Are you familiar with the industry standards relating to roller coaster safety?
Yes, I am.
How?
I am a member and the past president of the International Association of Amusement Parks and Attractions.
Your Honor, we offer Ms. Samantha Wax as an expert in roller coaster safety.
Do you have any cross-examination?
Not as to those qualifications, no, Your Honor. But we do take issue with the particular opinion that this expert gave in the report prior to trial. If Your Honor would like to take up that.
Is that something that's to do with the qualifications of this witness to render that opinion or unrelated to qualifications?
Your Honor, it's an opinion that we believe is outside of the scope of this qualification that's being tendered, as we believe it's an important legal opinion.
Understood. So why don't we get into that before the witness testifies? And you can remain on the stand, Ms. Wax. So please present your argument.
Your Honor, specifically within this witness's report, they offer an opinion that goes into the legal balancing test that the jury will have to decide today, whether the risk of injury outweighed the burden of precautions taken by the manufacturer. That is a legal opinion which is outside of the scope of the expertise of particular witness and would invade the province of the jury. As such, Your Honor, limit and preclude that opinion today.
And I just want to make sure I'm thinking of it correctly. What exactly do you not want to hear this witness say on the stand? Like, I can grab the report if you.
Your Honor, may I approach you with a report?
Oh, yeah, I'll take your copy. Sure.
Your Honor, I'm turning your attention to the second page where you'll find the headline opinions. And if I may, the language that we take issue with is the following. For each of the defects identified below, the risk of injury outweighed any benefits and outweighed the burden of remedying defects. Your Honor, we do believe that that's a legal opinion that's outside of the scope of this particular witness expertise and would invade the province of the jury, as that's the balancing test that they will have to perform when they deliberate today.
Mr. Jones, is this witness going to say, quote, the risk of serious injury outweighed any benefits and outweighed the burden of remedying such defects?
No, Your Honor.
make sure she doesn't say it, then we're gonna be okay. All right. Then your objection is sustained by agreement. Thank you.
May I proceed?
Yes, you may.
Let's talk about how you reached your conclusions. What information did you rely on?
Well, I inspected the ride myself. I inspected the tracks, the control panel, of each individual car. I also reviewed all of the exhibits and depositions in this case, including the deposition from the defendant's lead engineer who designed the ride.
What methods did you use?
I used generally accepted engineering principles as well as industry standards for safe roller coaster design.
Did you reliably apply that method to the information you had access to?
Yes, I did.
Were you able to reach a conclusion?
Yes,
Reach that conclusion to a reasonable degree of professional certainty?
I did.
Tell the jury. What was your conclusion?
I concluded that Grace Topping's lap bar released on July 6, 2020, because Hydra's wrath was active.
Defective how?
The lap bar system was not designed to handle the speed at which they would ride.
Why don't we break down that? Your Honor, permission for the witness to step into the well and use an exhibit.
Absolutely.
Ms. Wax, what are we looking at here?
This is a photograph of one of the cars from Hydra's.
Do you know where Grace Topping was sitting?
Grace Topping was sitting in the from the information I reviewed. And this is the lap bar.
Your Honor, let the record reflect the witness identified the last row of the roller coaster in the times.
Noted.
Actually work.
Well, single cylinder hydraulic system.
Those of us who aren't engineers, what does that mean?
Sure. That bar is connected to a cylinder underneath. That cylinder is filled with hydraulic fluid. As long as the pressure of that hydraulic fluid pressing down on the lap is more than any force being exerted on, flat bar stays closed.
Ms. Wax, you mentioned force, but what role does speed play in how a lap bar like that works?
Well, speed can increase the force with which a passenger contacts the lap bar, depending on the specific design.
Let's take a look at the design of the defense. Your Honor, publishing exhibit 8.
Okay.
Now, with the roller coaster that's like the defendants, what role would speed play?
Think about every time a passenger would contact their one. Every return, every upside down inversion, all the times the passenger would contact. The higher the speed of the roller coaster, the more force with the contact.
What happens if passengers exerting more force against their lap bar, and that lap bar is able to exert back on them?
The system fails. The bar. And they're nothing to keep passengers from 150 feet above.
Ms. Wax, were you here during the defense's opening statement?
Yes, I
Did you hear them say a couple of times that nothing was broken after July 6th?
did hear that.
So when the force of a passenger becomes the force of the lap bar, does that mean something would be mechanically broken?
No, you wouldn't see mechanical breakage. Think of it this way. It's like a door on. If a gust of wind blows that door, you're not going to see any mechanical failure on the door, but you would see it open. That's similar to what happened with the lap bar issue.
Thank you, Ms. Wax. You can retake your seat. Publishing exhibit 11.
Okay.
Ms. Wax, you told us that the roller coaster was being run at a speed that the lap bars were designed at. Now, according to the defendant, what speed was this designed at?
45 miles per hour max.
According to the defendant CEO, how fast were they roller coasters?
50 miles per hour.
During opening statement, did you hear the defendant's counsel say, hey, that's just a 5 mile per hour difference?
I did hear that.
It does seem like a small difference, Ms. White. How can that be a defect?
Well, it's not a small difference. We're not talking about a speed limit on the road, what a driver can handle. We're talking about a maximum engineering capacity, what a piece of machine can handle. Running a ride at a maximum engineering speed above speed is totally unsafe.
This lap bar ever professionally inspected at 50 miles per hour?
No, it wasn't.
Was it ever tested at 50 miles per hour?
Yes, for 5 minutes.
When the defendant did 5 minutes of testing at 50 miles per hour, how many people were riding the roller coaster?
According to the defendant's engineer, just that person, one person, the defendant's engineer.
Do we even know what seat that engineer was sitting in during those 5 minutes of testing?
The defendant didn't document it. At most, if I was tested 5 times, he couldn't.
Objection, Your Honor, it's a speculation.
Response to that?
Your Honor, it's not speculative. If the defendant ran 5 tests, at most, an engineer did 5 seats.
Overall.
Ms. Wax, do we know which seat that engineer sat during those 5 minutes of testing?
Well, the defendant ran it 5 times, so at most, the defendant could have written in 5 seats, but they didn't document which seats the defendant's engineer wrote in, so we don't know.
Do we know if the engineer tested the roller coaster in the seat that Grace Topping later sat in?
We don't.
Do we know if Grace Topping's lap bar was ever tested?
No, we don't.
Ms. Wax, statements when the defense said Grace Topping pushed her own lap bar button.
I did hear that.
In preparing this case, how many eyewitnesses did you find that said they saw Grace Topping press that button?
0.
Do you have any photos or video of Grace Topping pushing that button?
No, I don't.
Do you have any physical evidence suggesting Grace Topping pushed that button?
No.
Ms. Wax, what do you think, in your professional opinion, of the defendant's decision to put a release bar where passengers can reach it?
I concluded it was totally unsafe. That was actually another defect.
Why is putting a release button within a passenger's reach a defect?
This ride was open to minors, to children. The only thing keeping them in that ride was a single lap bar. This ride went upside down 150 feet in the air. The defendant gave children a button that could kill them.
To your knowledge, how many upside down roller coasters in the world? Lap bar release button within a passenger's reach.
Only the defendants.
Thank you for your time, Ms. Wax. No further questions, Your Honor.
Thank you.
I
Mr.
just,
Chuck.
I just asked the opposing counsel like me to deconstruct the easel in the well.
Mr. Giacomo, do you need a deconstruction?
Please, Your Honor, thank you.
It should be a simple process. Your Honor.
Whenever you're ready, Mr. John.
Good morning, Ms. Watts. I want to go ahead and start with the last thing you just told the jury about that button.
Of course.
Ma'am, like I said before, you're actually the president of a theme park yourself.
That's correct.
So we can agree you're well aware of the industry standards,
Yes,
standards on safety.
absolutely.
You're aware that that is a button that's required by industry standards.
The button is required, but not the location within the passenger's reach.
You did tell us that you took issue with the location of that button, but you do know other rides that actually have a button location in the same spot, don't you?
2 other rides that do not go upside down, yes.
So the answer was yes, you do know other rides with a button in that same location.
Yes,
Now, Your Honor, may I approach the witness with what's already in evidence as Exhibit 20?
Yes,
Your Honor, like a courtesy copy
yes, please.
showing opposing counsel.
Thank you.
May I also approach the jury, Your Honor?
Yes.
Thank you.
Thank you. Now, ma'am, let's talk about that button for a moment. That certificate, you know that hydras are up the same ride that you took issue with on location, true?
Yes, this is from the inspector who looked at the ride.
Ma'am, we can agree, when the inspector looked at that ride, the button was still on the side.
That's correct.
Nowhere on that certification can you point to the jury where it deemed that button unsafe at that location, could you?
No, the inspector does not document that.
I'm sorry, is it your testimony that the inspector doesn't document button location safety?
I'm saying on this inspection, there is no documentation of that.
Right, they didn't deem it unsafe.
According to this inspection report, that's correct.
Well, let's talk about what else that inspection report doesn't tell us. Throughout your direct examination, you told us that 45 miles an hour was dangerous for that rushing speed. Is that right?
That's correct.
You can't point to where on that certification it says you can't exceed a speed of 45.
No, they don't put that on the certificate. They did not put that on the certification.
They didn't put that on the certification. Nowhere on that certification could you point to if you increase that speed, these lap bars will experience issues, could you?
That's not on the certificate.
But it is your opinion that that was unsafe.
Absolutely.
You can push that over to the side. Now, you told us you actually went and you inspected hydrants with your belt,
That's correct.
and you looked at all aspects of the riot.
I did.
One of those things you looked at was the control system,
Yes, the operator control panel.
right? The same operator control panel that you saw has the ability to run up to 99 miles an hour.
That's correct.
That certification, ma'am, it doesn't say that you limited to run that ride at a certain speed, is it?
No, it doesn't.
But it is your opinion that there was a certain amount of force that overcame the hydraulics and that's what caused its release.
Absolutely.
Now, you mentioned one of the factors on direct examination and you mentioned speed. That was one of the factors to look at force.
Yes, that's one of the factors.
Right. One of the factors you didn't mention is the rider's weight.
That's not the factor. I calculated the speed, the weight, as well as the roads. Those are the factors I considered.
And I took down to make sure I got your words right. If you're exerting more force than the lap bar is designed to handle, it fails.
That's correct.
So we agree, more weight would mean more force.
Yes,
And in those materials you reviewed before trial, you actually saw that Jared Hackler, that same engineer you spoke about,
mhm,
ran tests on that,
yes,
4 different tests.
that's correct.
Man, Jared Hackliff weighed 190 pounds.
Yes, he did.
That ride was still running at 50 miles an hour.
Yes,
There were still the same 4 twists, turns, and inversions.
that's correct.
His lap bar never released once.
He didn't.
But you did take issue with the fact that you don't know which seat was tested. Is that fair to say?
Yes, we don't know if Ms. Talkbay's seat was tested.
So to confirm your theory, you tested Miss Topping's lap bar yourself, didn't you?
I did. I put crash test dummies in every seat.
10 different times. Not only are you testing her lap bar, you're testing every single lap bar on that ride.
Yes,
Like that 10 different times.
yes,
There are 7 different cars on Hydra's route.
that's correct. 14 passengers.
14 passengers each with their own lap bar.
Yes,
Now 14 times 10 different tests, 140 different kinds of flowers are being tested, right?
that's correct.
Not a single lap bar released during your tests either.
No, they didn't.
It's consistent with the tests for control and also
Yes, so it's consistent with my theory.
your theory that that lap bar was defective with more force.
Exactly. It's about probabilities. The lap bar isn't going to open every time, but it did open on Grace Topping's ride.
Ma'am, something you didn't talk to the jury about were some text messages you saw in this case.
No, I haven't talked about that.
That was something that you saw when you prepared for trial. Text messages where you saw Miss Topping talk about riding that ride in the park.
Yes,
She talked about that emergency restraint release
she did.
button that you know is only supposed to be used in case of emergency.
That's what they say. Unfortunately, it can work at any time.
It can work at any time, but you know that a ride needs to have this button in case of a fire, right?
Not in location. It is required to have the button.
But you just don't agree with a rider being able to use it in case of an emergency.
Absolutely.
Nothing further on that.
Any redirect?
Yes, Your Honor. Ms. Wax, you were asked about this certificate of inspection on direct examination. When the defendant received this certificate of inspection, how fast the ride run?
This inspection was dated March 4th, 2020, when the ride was running at 35 miles an hour.
Was the ride ever inspected at 50 miles per hour?
Not that I know of, no.
You were also just asked about that emergency release button. Ms. Wax, why is that a defect?
It's a defect because of the location. Passengers can release their lap bar at any time during the ride. That means that they can themselves push a button that would completely release their restraints and have nothing keeping them from falling out of the car.
Ms. Wax, opposing counsel just said, what if there's a fire? Don't we have that somewhere?
Industry standards require that that button exists, but it could be in a safer location, like the bottom of the car. And in that case, the ride operator or someone employed by the park would come and push it in an emergency.
How many roller coasters in the world put that button within reach of passengers?
3,
How many of those roller coasters go upside down?
only the defendant.
You were also asked about other times when the ride was run at 50 miles per hour during testing, and the lap bar didn't come up. And Ms. Wax said it was about probabilities. Could you explain what you mean?
Absolutely. It's about probabilities whether or not the force being exerted during that particular time is going to dislodge the lap bar. It's no coincidence that on the first day the defendant was running the ride at 50 miles per hour, Ms. Topping's lap bar dislodged, but it doesn't mean it would dislodge every time.
In this case, how long was it before one of the defendant's lap bar was dislodged?
On July 6, 2020, it took a little more than 4 hours.
Thank you for your time, Ms. Wax. No further questions.
Any cross?
No, Your Honor.
Ms. Wax, excused. Thank you. More witnesses for the plaintiff?
No, Your Honor.
Defense have any motions?
We do, Your Honor,
I'll hear now.
outside presence of the jury constructively.
Of course.
Your Honor, the defense moves for a judgment of matter of law pursuant to Federal Rule of Civil Procedure 50A1. Even when viewing the evidence in the light most favorable to the non-moving party, the plaintiff here has failed to put forth sufficient evidence from what a reasonable jury would find in their favor today. Your Honor, the plaintiff had to provide evidence that there was a defect on the ride. They provided 2 different theories as such, and both of them were hypothetical. We learned that the button on the side was in fact safe. It was required by the industry standards, and that Klein County came and inspected that ride and found that the location was sufficient. Further, Your Honor, we did hear that the lap bars could handle speeds that exceeded 45 miles an hour, as Mr. Hackliff tested the ride himself. Therefore, we ask that you grant our motion.
Response?
Yes, Your Honor. Viewing the evidence in the light most favorable to the plaintiff, you have evidence on the record that button was a defect, and running the ride at 50 miles per hour was also a design defect, and that those design defects caused Ms. Topping's injuries. The jury would take this as true when viewing the evidence in light most favorable to the plaintiff, so we ask to deny the defendant's motion.
I find plaintiffs have presented sufficient evidence of both their design claims, so for that, I will deny the defense motion.
Your Honor.
Any other motions?
No other motions. The defense is ready to proceed whenever Your Honor is to do so. We just asked to collect the exhibit from the jury.
Why don't we take a 5-minute break for purposes of restroom or stretching legs or anything else? You do what you need to do, and then we'll start with your case when we get back.
Yes, Your Honor, may I approach the jury?
Absolutely.
No, 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 not at all. Thank you.
Plaintiff is used 15 seconds. The defense is 55 seconds.
Thank you. Mhm. One of four.
Yeah. I'll plug that in. Yeah. No, I got that.
Jurors all set? All set, all right. Before we go on the record with defense case, anybody have anything they need to bring to my attention? You good to go?
Nothing from the defense, Your Honor.
Plaintiff, you good?
Yes, Your Honor.
Okay, please proceed.
The defense calls Alex Watson to the stand.
Ms. Watson?
May I
Whenever
proceed?
you're ready, Ms. Padron.
Ms. Watson, go ahead and turn and introduce yourself to the members of the jury.
Yes, good morning. My name is Alex Watson.
Ms. Watson, what do you do for a living?
I am the owner and CEO of Dragon World Amusement Park.
Can you tell the jury about Dragon World?
Of course. So Dragon World is an amusement park for both younger kids and also older adults, age 1 through 99, and it is themed around dragons. I wanted to create a Disney-like park, but more affordable for families. Disney is very expensive, and for a family of 4, it can cost thousands of dollars to go. So we wanted to create a more reasonable park for families in the area.
Now, Ms. Watson, you've been in the courtroom all day, and we've heard a lot about your decision to increase the speed of Hydra's route. I want to walk the jury through the steps that you took before you made that decision. First, why did you want to increase the speed?
Objection to relevance. May I be heard?
Yes, you may.
The question as phrased was, why did you want to increase the speed? We pled this case as a strict liability case. There is no element of the claim about motive, and thus this is not relevant.
Response?
Your Honor, I'm establishing background as to why they increased the speed.
Why isn't relevant to just the jury understanding the context of the ride and why they would want it to be faster?
Because, Your Honor, since it is a strict liability case, we don't have motive evidence that is relevant.
Response to that?
Your Honor, this is simply background information. I have no problem moving on.
Objection sustained.
All right, Ms. Watson. Did you come to this decision to increase the speed by yourself?
No, I consulted with our park engineer, Mr. Jared Hatcliffe.
And after you consulted with Mr. Hatcliffe, what did you do?
We ran 4 tests on the Hydra's Wrath ride at the 50-mile-per-hour speed.
Where were you when these tests were conducted?
Oh, I was there when the tests were conducted. I watched as the ride went around the track the 4 times at the higher speed.
What did you observe?
I observed nothing out of the ordinary, nothing wrong with the carts, track, the control panel. when the ride
Objection
was-
to improper expert opinion. May I be heard?
Yes.
This witness, all we've heard is that she's a CEO of Dragon World. We haven't heard that she's an engineer, yet right now she's testifying that there was nothing wrong with the testing done before they ran the ride for passengers at 50 miles per hour. This witness would need specialized knowledge to be able to testify to that opinion. And so it's an improper opinion at this point.
Is she giving an expert testimony or is she giving us her observations of what she saw?
The language of what the witness said was that nothing was wrong with the ride. That's an improper expert opinion.
Your Honor, may I be heard?
Yes, you may.
This witness was just testing what she witnessed while she was observing the tests. From her appearance, there was nothing wrong with the ride because she saw it run fine. She's not opining on any mechanics or anything of that nature, simply as to what she witnessed on those test runs.
You're not going to use this witness as a conduit for expert witness testimony, correct?
No, this is not an expert witness.
So I'm going to sustain the objection to the extent that this witness is not permitted to give expert testimony. However, in the context of how you explained the background of her observations here, I think the jury gets that and we can proceed.
All right. When were these test runs conducted?
They were conducted on June 5th, about a month before we reopened the park.
Now, Ms. Watson, how did you let people know about the speed increase?
We did advertisements on social media, Instagram, Twitter, Facebook, and we also put up several billboard signs along the highway.
How much did you spend on advertising?
About $25,000.
And how long were you advertising for?
We were advertising for a month until the park reopened on July 6th.
Ms. Watson, has Hydra's Wrath ever been inspected before?
Yes, it has.
Would you recognize that certificate of inspection?
Indeed, I would.
Showing opposing counsel what is in evidence as Exhibit 20. Your Honor, would you like a courtesy copy?
Is this a certificate of inspection? I already
Yes.
have it. Thank you.
Permission to approach the witness?
Yes, you may.
Permission to publish to the jury by way of handout?
Yes, you may.
Ms. Watson, can you tell the jury what they're looking at?
Of course, this is the certificate of inspection of the Hydra Rafts roller coaster dated March 4th of 2020.
Do you know what an inspector looks at when they inspect a ride?
Yes, ma'am. They look at the carts on the track, they look at the track itself, and they also look at the control panel.
Now, what triggers an inspector to come out?
There are three things that can trigger an inspection. One, when a ride is first installed, and a new ride at the park, that can trigger an inspection. When you request an inspection, you can have an inspector come out and inspect a ride, and also every 6 months. That's a standard time frame for an inspector to come.
Why didn't you have Hydra's Wrath inspected at the higher speed of 50 miles an hour?
Oh, we did our own internal tests 4 times, again, on the June 5th date.
Now, Ms. Watson, we've heard a lot about this button. The plaintiff's expert actually said that it was totally unsafe. As the owner of Dragon World, why do you have the button on Hydra's Wrath?
We have to have the button on Hydra's Wrath. It is a safety feature for the button to be on the cart. If there was an emergency, we need to have that button on the cart for the passengers to release their own restraints.
Now, I want to move to the speed. How would the ride operator increase the speed on Hydra's Wrath?
So on the control panel, there is a dial. The speeds can be, they're 2 digits from 1 to 99. And the ride conductor can increase the speed of the ride using the dial. So the ride inspector just simply turned up the dial from 35 miles an hour to 50 miles an hour. But we've never gone above 50 miles per hour on that roller coaster.
Ms. Watson, go ahead and take a look at the certificate. Where is there a speed limit on the certificate?
There is not one listed on here.
Where on the certificate does it say anything about additional restraints for a higher speed?
There's nothing about additional restraints for a higher speed on here.
Where was this adjustable speed panel? Where was it when Hydra's Wrath was certified in 2020?
Well, it's in the same location that it is now. It's right in front of the ride.
Did it have the same adjustable capability when it was certified?
Yes, ma'am. We have not made any changes to the control panel besides the increase in speed since this ride was inspected.
As the owner of Dragon World, are you aware of any regulations that limit roller coaster speeds?
Not in Klein County.
Moment to confirm. No further questions, Your Honor. Just permission to collect exhibits from the witness and the jury.
You may. Plaintiff cross-examine
Yes, Your Honor.
whenever you're ready, Ms. Gaskins.
Good morning, Ms. Watson.
Warning.
Let's start by talking about your decision to increase the speed of your ride.
Yes, ma'am.
Your Honor, may I approach the witness with what's already in evidence as Exhibit 23? Would
Yes.
you like a courtesy copy?
23 is,
The email.
I would like that, please. Thank you.
These are emails between you and your internal engineer, right?
Yes, ma'am, Mr. Jared Hackcliffe.
In these emails, you're talking about the speed of Hydra's wrath, correct?
Yes, ma'am.
Let's start at the bottom of this email chain.
Objection, Your Honor.
Yes,
These emails actually go into the background of the same background that opposing counsel objected to earlier about the pandemic. Just want to make sure that we're being consistent.
well, are you objecting to the admissibility of anything in these emails?
Yes, relevance.
Okay, what specifically?
The first email goes into our rides are getting stale. You've ridden them once, you've ridden them 100 times. I want to give riders a reason to come back to the park, going to his motivation to increase the speed, to increase riders.
May I respond?
Yes,
Your Honor, these emails are already in evidence, but even so, we're not concerned with those portions and we'd happily redact them.
so you're not going to go into that with this witness anyway.
No.
Okay by you?
Yes, Your Honor.
Looks like we're good. You may continue.
Let's start at the bottom of this email chain. This would be the first email that you sent your internal engineer, right?
Yes, I sent the first email on May 25th.
The subject line of that email is increased speed on Hydra's wrath, right?
That's correct.
Now, your ride originally ran at 35 miles per hour, didn't it?
Yes, that is correct.
In this email, you tell your engineer, let's bump it up to 50.
Yes, I asked if that is something that we could possibly do.
You said all you have to do is turn up the speed on the control panel.
Yes, that is how you increase the speed on the ride.
Your Honor, may I
Yes.
approach? It was my understanding that this first email was redacted.
May I respond?
Yes,
Only the portions dealing with the motivation of this witness were redacted.
that's what I understood.
Okay.
We on the same page?
Yes, now we are.
Do you have any objections to anything else? So
No,
good?
Your Honor.
Okay, you may proceed.
When you told your engineer, let's bump it up to 50, the first thing he said to you was, Alex, not sure about that.
Yes, that is correct.
He says Hydra's wrath wasn't designed with that speed in mind.
Yes, that is correct.
Your engineer was concerned about how that increased speed would affect the restraint system.
Yes, that is correct. He was concerned about the restraint system and also making the ride smooth. That's why I suggested that we run the tests so that we could talk about it more and actually see the ride in action at the increased speed.
But redirecting you back to my question, your engineer was concerned about how that increased speed would affect the restraint system, right?
That is correct.
Ma'am, the person who said Hydra's wrath wasn't designed with that speed in mind, that's the man who designed the ride, right?
He helped design and build the ride. Yes.
And that restraint system, those are those lap bars, right?
Yes, the hydraulic lap bars.
Let's talk about whether you made sure it was safe to increase the speed of your ride. You said in direct examination that you tested it at this increased speed, right?
Yes, we did. We conducted 4 tests at the increased speed.
Well, we'll get to that, but first, you tested it at 50 miles per hour, right?
That is correct.
Your ride has 14 individual seats on it, right?
That is correct. 7 cars, 2 seats per car.
7 cars, 2 seats per car. That means 14 individual lap bars, right?
That is correct.
When you ran that testing, you didn't put crash dummies in all 14 of those seats, did you?
No, ma'am. Our engineer, Mr. Hackliff himself, sat in the ride.
So you didn't put crash dummies in all 14 of those seats, did you?
No, that's correct.
You didn't ask your employees to fill up all 14 of those seats, did you?
That's correct.
You didn't ask your engineer to sit in each one of those 14 seats, did you?
That's correct.
Under each one of those 14 lap bars, did you?
We didn't ask him to sit in each seat with the lap bars down. He just sat in a seat 4 times.
You didn't ask him to sit in each one of those seats with the lap bars down, right?
That's correct.
You had him sitting in one seat, right?
We had him seated in the Hydra's wrath. I do not remember which seat or how many seats he sat in. He just sat in a seat while we did the tests.
Okay, let's break down what you just said. You said you don't remember what seat he sat in?
No, I do not.
So you don't even know if he sat in the seat that Miss Topping later sat in. Isn't that true?
That's correct.
You don't remember what seat he sat in. So he only sat in one seat, right?
I do not remember if he only sat in one seat or if he changed seats during the other tests that we conducted.
So you don't remember. If he only tested just one lap bar, isn't that true?
That's true. I know that he was there on the ride with the lap seat restraint down at 50 miles per hour. I do not remember which seat number he was on. I do not remember if he changed seats during the tests. However, I do know that he was on the ride while we ran it at the increased speed.
Well, let's talk about what those tests look like. You ran your roller coaster 4 times during those tests, correct?
That is correct.
It takes about a minute to go around the track,
About, yes,
but no longer than a minute, true?
true.
So 4 times around the track, 1 minute each time. You ran your roller coaster for 4 minutes?
That's correct.
After you ran your roller coaster for 4 minutes, a month went by before you let passengers on it.
That's correct.
In that month, you didn't ask your engineer to sit in all 14 of those seats, did you?
No, we had already conducted our 4 tests.
Said you already conducted your 4 tests. You never asked him to test it again?
No, I did not.
Let's talk about your decision to put a button on the side of your roller coaster. Ma'am, your roller coaster goes 150 feet high, doesn't it?
That is correct.
It goes upside down, doesn't it?
Multiple times.
It goes upside down multiple times, 150 feet high, doesn't it, ma'am?
It does.
When someone is 150 feet in the air, the only thing keeping them in place is their lap bar. Isn't that true?
That is correct.
When they're upside down on your roller coaster, the only thing keeping them in place is that lap bar.
That is correct.
You put a button on the side of your roller coaster that would release that lap bar?
Yes, ma'am, we did. By regulation, we had to have a release bar on the carts for individual passengers for safety reasons. If there was a malfunction, we had to make sure that guests could release themselves.
Redirecting you back to my question. You put a button on the side of your roller coaster that would release the lap bar, right?
That is correct.
You told us a moment ago that this is required by regulation. You need it, right?
That is correct.
There is no regulation requiring you to put that button within reach of your passengers, right?
There's no regulation stating where you can or cannot place a button, just that it had to be on the cart somewhere.
Right, ma'am. There's no regulation saying where you can or can't put that button. So there's no regulation requiring you to put it within reach of your passengers. Isn't that true?
That is correct.
There's also no regulation that says it works when the ride is moving, right?
So you're asking that there's no regulation that while the control panel is on and operating, that the individual release button also has to be on and operating.
Ma'am, let's break that down.
Yeah.
Your button works at any point during the ride, doesn't it?
Yes, that is correct.
It works when it's stopped.
Yes, that is correct.
It works when it's moving, right?
That is correct.
You didn't make it so that that button only works when it's stopped, right?
That is correct.
This ride is available to kids, isn't it?
It is available to kids who are above a certain height. So not all kids can ride the ride. There is a height limitation, but if there was a minor who met that height requirement, then yes, they would be able to ride the ride.
It's available to kids.
Yes, with conditions.
Let's get back to the speed of your ride. Before July 6th, your ride always ran at 35 miles per hour, didn't it?
That is correct.
It ran at 35 miles per hour for 6 months, didn't it?
A little under 6 months. Yes,
A little under 6 months, it ran at 35 miles per hour all day, didn't it?
That is correct.
every single day, didn't it?
Yes, during our hours of operation.
During those almost 6 months when it ran at 35 miles per hour, a lap bar never came up in the middle of the ride, did it?
Objection, Your Honor, relevance. The plaintiff have alleged that this ride became defective when the speed was increased to 50 miles an hour. The ride running at 35 months prior is not relevant here.
Yeah, why does it matter that there was never a problem 35 miles?
That goes exactly to our point, Your Honor, that the second they bumped it up to 50 miles per hour, this ride became defective, but the speed was the defect. So the fact that it never had an issue at 35 miles per hour means it was safe at 35 miles per hour and defective at 50.
What do you say to that?
Your Honor, it has already been established that the ride was running at 35 miles an hour and then speed increased to 50.
It's cross-exam, this is proper, objection overruled.
At 35 miles per hour, a lap bar never came up, did it?
That's correct.
At 35 miles per hour, nobody got hurt on your ride.
That's correct.
July 6th was the first day that, in your own words, you bumped it up to 50, right?
Yes, when we reopened, that it's the first day that the ride ran at 50 miles per hour.
The first day that your ride ran at 50 miles an hour, a lap bar came up, didn't it?
That was the first day that one of our cars had their lap bars released. Yes.
The first day your ride ran at 50 miles an hour, Miss Topping died.
Yes, that is correct.
Thank you. I have nothing further.
Thank you. Any redirect?
Yes, Your Honor. Ms. Watson, on July 6th, are you aware if the ride was running all morning?
It was running during the morning when our park opened. Yes.
Did any other lap bars release?
No, they didn't.
You mentioned earlier that this button has been on Hydra's route since you created the ride.
Yes.
Have you ever had an issue with the button before?
No, no issues before.
No further questions, Your Honor.
Recross?
No recross.
We ask that Ms. Watson step down.
She can do that. You're excused. Thank you.
Thank you.
Vince, any other witnesses?
Yes, Your Honor. At this time, we wish to call Jared Hackliff by way of deposition. He was stipulated unavailable pursuant to the court's pretrial order. We did speak with opposing counsel prior to trial today and showed them the portions that we wish to designate today on the record. May my co-counsel take the stand and read the answers that I posed to her from the deposition, Your Honor?
Absolutely. Before you do that, was there any objection to the testimony that they're seeking to read in?
Yes, Your Honor. Would you like me to object now or when we reach the relevant portions that I wish to object to?
That's object now. That makes sense. So let me just get the deposition up on my.
Your Honor, I can approach with the copy if you'd
Oh,
like a hard.
Thank you. I appreciate that. Thank you. Okay, page and line counsel for your objection, please.
Yes, Your Honor, there are 20 some lines that opposing counsel tends to read. Our objection is to 11 of them.
What,
On page 3, particularly from lines 57 to 61. Those are the most critical lines.
give me one moment to read it. Through 61, you said?
Yes, Your Honor.
Okay, what's your, and this is defendant's, what is Mr. Hackliff's position?
This is the rides engineer, yes.
Okay. Okay, what's wrong with this testimony?
It's an improper opinion, Your Honor.
Why is that?
Because before, first of all, the testimony is clearly opinion testimony. The question begins, in your opinion, could the hydraulics handle speeds up to 50 miles per hour? Mr. Hackliff then opines about whether or not that was safe. Now, before that sort of opinion testimony can come onto the record, the requirements of Rule 702 need to be satisfied. Now, specifically, we don't know what method Mr. Hackliff used to reach this opinion. We don't know if that method was reliable. We don't know if it was reliably applied. If that witness were here and on the stand, we'd be able to, all those requirements would have to be met and we'd have the opportunity to cross-examine them. In this deposition, that's not satisfying.
Why isn't it a lay opinion?
Your Honor, it's an engineer giving an opinion about what a hydraulic system could handle. That's not something a lay witness can testify to under Rule 701 because it's based on specialized knowledge. Specifically, Rule 701C moves that sort of opinion testimony under Rule 702 where the court acts as a gatekeeper.
One more question, then I'm going to turn it over to your opposing counsel to argue. Why can't this testimony be construed as him making an observation of the operation of the roller coaster as opposed to an opinion in an expert witness sense, which is based on reviewing a file and arriving at an opinion based on education, training, and experience?
Well, Your Honor, if the testimony were the specific steps this engineer took, how he designed the ride, something like that, that would be permissible. But that's not what this testimony is. The question is, in your opinion, could the hydraulics handle speeds up to 50 miles per hour? That's not an opinion of a lay witness. That's expert testimony.
Response.
Yes, Your Honor. If I may start from the beginning, throughout plaintiff's case in chief, not only have they offered Mr. Hackliff's position and his role and what the ride's design was and was capable of handling, but they also designated their own portions. Not only did they designate what Mr. Hackliff's job was, what he did for a living was, I'm sorry, Your Honor, I believe my microphone might be a little, I'm going to move it down and see if that makes it better. They designated during their case in chief that this was the head of engineering at Dragon World. And further, Your Honor, on the same page, just before the lines they take issue with, they offered in their case for the hydraulics designed with a speed of 50 miles per hour in mind, turning your attention to that same page, line 53, 54, 55, and 56. They had that witness answer. They were designed to handle speeds up to 45 miles per hour. This is the same type of opinion testimony, without the three words in your opinion. This witness can still render their lay opinion as to the hydraulics, whether they can handle speeds higher than 45. It is based within their scope of expertise, and the jury deserves to hear that.
Do your designations include lines 53 through 56?
Yes, Your Honor. As a matter of fact, they are from that top of the page, lines 50 through 61.
One last shot.
Your Honor, the testimony is entirely different. From lines 53 to 56, the engineer is saying the steps that he took. This is what I designed the roller coaster to handle. That's a lay opinion. To then go beyond and ask his opinion about how far beyond what he designed the roller coaster for it would be safe at is an opinion. And Your Honor, is further evidence that this is an opinion testimony. The defense is about to call an expert witness to the stand to give this sort of an opinion.
Your Honor, may I be heard on those grounds? Or
Quit when you're ahead. So I'm going to overrule your objection. And the reason being is that understanding this is a specialized witness who has specialized education, training, experience. He's an engineer. However, in reading the testimony in the context of the other testimony, I interpret this as him giving his factual observations. Now, of course, that does enter into a little bit expert testimony because everything the guy sees and hears and talks about is technically expert testimony because he's an engineer. So I do not believe this is improper testimony. I'm going to allow the defense to read it.
yes, Your Honor, may Ms. Padron take the stand?
Yes.
For the record, this is the deposition of Jared Hatcliffe taken August 5th of 2021. Turning court and counsel's attention to page 1, lines 4 through 11. Can you state your name for the record?
Jared Hackliff.
What do you do for a living?
I'm the head of engineering at Dragon World.
What are your responsibilities?
I design our rides and attractions. I oversee the design process through construction and testing. I'm also responsible for maintenance on rides after they open.
Now turning court and counsel's attention to page 3, lines 50 through 61. What ride speeds were the hydraulics designed to handle?
In design, we tested the ride at speeds of 15 miles per hour, 30 miles per hour, and 45 miles per hour.
Were the hydraulics designed with a speed of 50 miles per hour in mind?
They were designed to handle speeds up to 45 miles per hour.
In your opinion, could the hydraulics handle speeds up to 50 miles per hour?
They handled the speed when we tested it at 50 miles per hour in June 2020, and the ride worked just fine up until the afternoon of July 6, 2020, when Grace Topping was hurt.
I'm turning court and counsel's attention to page 4, lines 86 through 92. Why did you design Hydra's Wrath with buttons on the side of the cars to release the restraints?
All roller coasters have a manual backup restraint release somewhere in the ride. That's standard for roller coasters. It's necessary in case of an emergency. We thought it would be useful to have a release on the cars so guests could be evacuated easily and safely.
Now turning your attention to page 6, lines 123 through 125. Why did Dragon World not get Hydra's Wrath inspected at 50 miles per hour?
Because we did our own test runs at that speed.
Now turning your attention to page 7, lines 144 through 146. Why would increased speeds affect the lap bars?
Guests would contact the lap bars. We needed to make sure that the riders wouldn't be uncomfortable.
Finally, turning your attention to page 8, lines 175 through 177. Approximately how much did you weigh on the day you tested Hydra's Wrath in June 2020?
About 190 pounds.
Thank you, Your Honor. We have no further designations.
Thank you. You may call your next witness when you're ready.
The defense calls Cole Kent.
Kent, you may take the stand. Giacomo, whenever you're ready.
Good morning. Could you please turn and introduce yourself to the members of the jury?
Good morning. My name is Cole Kent. I own Kent Consulting LLC and also teach a mechanical engineering class at Klein County Community College.
Tell us a little bit about your company. What type of work do you do there?
We consult on amusement park operations. About 20% of our work has to do with ride safety or mechanics.
When you say ride safety or mechanics, can you explain what that means?
Yes, the roller coaster industry, like any other industry, has standards and regulations that amusement parks are required to meet before they open their product to the public. I've become familiar with these standards and regulations. I've been in this industry for well over a decade.
Tell us a little bit about you. What's your educational background that qualifies you for your position?
In 2007, I graduated from Penn State University with a degree in mechanical engineering.
What'd you do after college?
I've been in this field ever since. I worked for an amusement park outside of Pittsburgh. I assisted in designing and manufacturing 4 of their roller coasters. Then I worked for a roller coaster manufacturer and helped design a dozen of their roller coasters.
Ms. Kent, have you ever provided your consulting services in a case like this in the past?
I have. I've consulted on 62 cases. In 59 of those cases, I consulted for the amusement park or equivalent. And in 3 of those cases, I consulted for individuals who believed to have been harmed at an amusement park.
What about testifying? Have you ever actually come to court and testified before?
Yes, I've testified 5 times for amusement parks or the equivalent.
Tell us, what's your standard rate when you do consulting in a case like this?
My standard rate is $1,000 an hour.
How much time did you spend on this case in particular?
I've worked 26 hours.
I know this is a silly question, ma'am. Can you tell us how much money have you made on this case?
Yes, $26,000.
Your Honor, at this time, we tender Ms. Kent as an expert in mechanical engineering of roller coaster design, as well as safety regulatory compliance.
Any cross-examination on qualifications?
No, Your Honor.
The court will accept this witness as an expert in those fields. You may proceed with your examination.
Ms. Kent, I want to turn our attention to this case. Earlier in trial, we heard about 2 different defects that the plaintiff's engineer found on Hydra's Wrath, one being the speed and one being a button location. Have you come to opinions about those 2 different functions of Hydra's Wrath?
Yes, I have.
And those opinions, are they based within a reasonable degree of professional certainty within your field?
Yes.
Let's go ahead and start with the speed of Hydra's Wrath. What's your opinion about that speed increase and whether that ride was capable of handling?
Hydra's Wrath was capable of handling the 50-mile-per-hour speed, and it was not defective because of it.
All right, can you walk us through that a little bit? How did you come to that finding?
I took all the evidence in this case, the multiple times that this ride had run at 50 miles per hour, as well as the fact that nothing on this ride was mechanically broken.
When you say the multiple times this ride was run at 50 miles an hour, can you expand?
Yes, this ride was run at 50 miles per hour in June of 2020. Alex Watson, the CEO of Dragon World, when he decided to increase the speed of this ride, consulted with his engineer, Jared Hackliff, and they conducted confirmatory test runs.
When you say confirmatory test runs, what do you mean by that?
They were testing to see if this ride could handle the 50-mile-per-hour speeds, to see if the lap restraints would fail, and in none of those instances did the lap bars open.
Are you aware with what this ride was designed to run at from the beginning?
Originally, this ride was tested at 45 miles per hour, but it is clear now that this ride could handle that 50-mile-per-hour speed.
Now, just before you mentioned several different times this ride was running at 50. Can you tell us about those other times?
Yes, I can. On July 6, 2020, that ride was running all morning with full cars of people, and in none of those rides did any lap bars open. Additionally, I conducted test runs with Miss Wax on August 6th of 2020, and in none of those test runs did any lap bars come up.
Now, I want to talk a little bit more about those test runs you ran in just a moment, but can you tell us, based on your experience in the field, what safety regulations required Miss Wax to reach out to the ride's engineer and run those confirmatory tests?
No regulations require Mr. Watson to do that.
What regulations are you familiar with that required Miss Watson to limit the speed of Hydra's Wrath to 45 miles an hour?
None. This ride could theoretically go up to 99 miles per hour. There was no regulation prohibiting it from running any particular speed.
Let's go back and talk a little bit about those tests you ran. Can you tell us what were you looking for when you were testing this ride?
Yes, I was looking to see if anything was mechanically wrong, if anything had failed, if anything was broken or missing, to determine why this lap bar would have come up on the afternoon of July 6, 2020.
What did you find mechanically wrong?
Ms. Wax and I actually came to the same conclusion in that instance. Nothing was mechanically wrong, no parts were missing. This ride was functioning perfectly fine.
After seeing it was functioning fine, did you continue looking at what was wrong?
Yes, we wanted to test the theory. And so we placed dummies in every single seat and ran it around the tracks 10 times at 50 miles per hour.
How many lap bars released during your testing?
None.
Ma'am, earlier we heard a little bit about the different factors that go into determining the amount of force placed on a lap bar, and one of those things were speed. Do you agree with Ms. Wax's finding that the speed increase can actually impact the amount of force on a lap bar?
I do agree with that opinion. However, the evidence in this case does not support that being the issue here.
Why do you say that?
Well, none of the lap bars opened during any of the test runs conducted in June of 2020 at 50 miles per hour. The entire morning of July 6, 2020, none of those lap bars opened. And during the 10 test runs that Ms. Wax and I ran in August, none of those lap bars came up either.
Now, earlier throughout trial, we heard that Jared Hackliff weighed 190 pounds at the time he ran those tests. In reviewing materials, do you know how much weight Miss Topping was when she was on that ride?
Yes, I do. Ms. Topping weighed 135 pounds.
Ms. Kent, let's now turn our attention to that button we've heard about. Now, earlier in trial, we heard Ms. Wax say that the button was in a location that could kill the riders. Do you agree with this opinion?
I do not agree with that opinion at all, no.
Can you elaborate? Why don't you agree with that?
Yes, I can. The safety regulations require that there be an emergency release somewhere on a ride. Although I have not personally researched this issue, the purpose of the button is so that the rider can release themselves in case of a fire, in case of an emergency, or in case that the ride operator does not act in time. The rider needs to be able to reach that button or that release, in my opinion.
Are you aware of this ride ever having issues with the button's location in the past?
No.
And that button location, what is your opinion about whether a rider can accidentally hit it?
It is my opinion that that button and its current location on the outside of the car in the upper corner could not be inadvertently hit.
If it's not your opinion that this speed increase caused this, or that it's your opinion the button location is safe, then why do you believe that this happened?
It is my opinion that the only reason this lap bar opened is because the rider, in this case, Ms. Topping, pressed the emergency release button, releasing the lap bar.
Ms. Kent, hypothetically, today we've heard that the lap bar restraint was the only thing keeping Miss Topping in place. Had there been some other form of restraint system, how is it affected if a rider actually presses that release button?
Well, the whole point of the emergency release button is so whatever restraint is keeping you in place, once you hit that, it will open.
Should this, excuse me, what is your opinion about when this ride should be able to have a rider press that button? Should it only be when the ride stopped, or?
Whenever there's an emergency, that's the purpose of the button, and the rider needs to be able to reach that button in order to save themselves in case of an emergency.
Your Honor, I have nothing further.
Any cross-exam?
Yes, Your Honor.
Go for it.
Ms. Kent, can you see that all right?
Is there any way I can
That's
move
all right,
out
I'll
just a
move it.
little bit? Sorry.
No problem. How about now?
That's perfect right there. Thank you.
Excellent. May I proceed?
Yes, you may.
Ms. Kent, good morning.
Good morning.
This isn't your first time testifying in court, is it?
No, it is not.
Like you told us on direct examination, you've testified in court 5 previous times, right?
Yes, I have.
All 5 times on behalf of amusement parks.
Yes,
Now, you've been retained in 57 other cases that didn't go to trial.
yes,
In 3 of those cases, you were retained by an individual who had been hurt at an amusement park.
yes,
In the other 54 cases, you were retained by the amusement.
yes,
Here today in court, you've been retained by another amusement park.
yes.
So let's talk about your opinion that Grace Topping pushed her own release button.
Okay.
You reviewed exactly 5 witness statements in this case, didn't you?
Yes,
Exactly 0 of those witnesses said they saw Grace Topping push that button, right?
that is correct.
You don't have any video of Grace Topping pushing that button.
No, there's no video available.
Some theme parks, they take pictures of people with their hands in the air on a roller coaster. You've seen that, right?
Objection, Your Honor. May we approach?
Sure.
As to relevance, Your Honor, whether other theme parks do or don't have video surveillance is not at issue in this case. He just established that Miss Kent is unfamiliar with any other statements in this case that actually show that Miss Topping pressed this button. This is no longer relevant.
This is an expert in this particular field who has experience and knowledge of amusement parks and rides like this one, in addition to this particular one. So I think this is proper cross-examination of this witness's knowledge of the field.
Yes, Your Honor. So Ms. Kent, some roller coasters, they take pictures of their riders with the hands up in the air like this, right?
Yes,
You don't have any pictures in this case where everyone has their hands in the air, but Grace Topping has her hands on the button, right?
I do not have any of those photos in what I was given. No.
Publishing Exhibit 11.
Okay.
You actually had the opportunity to examine the roller coaster that Grace Topping rode, right?
Yes, I did.
And it's your opinion that her finger pressed that button, right?
That is my opinion.
Ms. Kent, you don't have fingerprints from that button, do you?
No, I'm a mechanical engineer. I did not take any fingerprints.
So that's not something that you have.
No.
Let's talk about another way that somebody can fall out of a roller coaster. The defendant used to run their roller coaster at 35 miles per hour, right?
That is true.
Then the defendant increased the speed.
Yes,
The day Grace Topping died, the roller coaster was running at 50 miles per hour.
yes,
Ms. Kent, you would agree with me that when you make a roller coaster faster, you increase the frequency with which a rider contacts their lap bar, right?
I do agree with that.
When you increase the speed of a roller coaster, you increase the likelihood that the hydraulics will fail.
Yes, I do agree with that, but the evidence does not support that in this case.
Ms. Kent, you agree that if you increase the speed, you increase the likelihood of the hydraulics failing, yes?
Yes,
If you increase the speed, you increase the likelihood of a lap bar coming up during a ride.
yes, but the evidence does not support that in this case.
Ms. Kent, I'm looking for a yes or a no here. If you increase the speed, you increase the likelihood of a lap bar coming up, yes or no?
Yes,
Now, on direct examination, you told us that you ran some tests of the roller coaster at 50 miles per hour.
yes, along with Ms. Wax.
You didn't have a single live passenger in the car during those tests.
No, we put dummies in each seat.
And here's the thing, Ms. Kent, none of those crash dummies that you used actually weighed as much as Grace Topping. Isn't that true?
They did not weigh as much as Grace Topping, no.
Let's talk about why Grace Topping died. The defendant began running their roller coaster in October of 2019, right?
Yes,
At 35 miles per hour.
yes,
Ms. Kent, the day the defendant increased the speed to 50 miles per hour, Grace Topping died.
it had been increased in June, but the first day it was open to the public, yes.
The ride had been open to the public at 50 miles per hour for 4 hours. Isn't that a fact?
Yes,
Thank you for your time, Ms. Kent. No further questions, Your Honor. I can remove the easel.
Please.
Direct? and
Yes,
the
Your
easel?
Honor. No easel necessary. Thank
Okay.
you. Ms. Kent, you were just asked about evidence that Ms. Topping pressed her emergency restraint release button. Can you tell us how many riders had their lap bar release on July 6th of 2020?
just one.
And you just said that that ride had been running for 4 hours. How many riders are you familiar with that didn't come back after they were on that ride?
During those 4 hours,
Yes, ma'am.
none.
Whose lap bar do you know released from that day?
Grace Toppings.
Nothing further, Your Honor. We ask that this witness step down, barring any recross.
Any recross?
No, Your Honor.
You're excused. Thank you. Any other witnesses or read-ins or anything like that?
Nothing, Your Honor. The defense does rest.
Any motions?
Yes, Your Honor.
All right, let's hear it.
Your Honor, the defense re-raises our motion for a judgment as a matter of law. Still, when viewing the evidence in the light most favorable to the plaintiff, they have still failed to put forth sufficient evidence as to a defect today. Your Honor, we have just heard from Ms. Kent, not only that that button location was not unsafe, but that there were other riders on this ride all day on July 6th. There had been testing before and after this ride had increased the speed, and there had never been a malfunction with these hydraulics. They have failed to meet their burden, and therefore we ask that you grant our motion.
Really brief. Really brief response.
Viewing the evidence in the light most favorable to the plaintiff, a reasonable juror could find that there was a design defect in the defendant's ride and that it caused Ms. Topping's injuries.
Motion denied.
We're ready to proceed to closings.
And I leave it to counsel. If you want to take 5 minutes in order to get your acts together before closing, I'm happy to accommodate that. But if you want to jump in right now, you can do that too.
Yes, Your Honor, we would like 5 minutes to get our act together.
There you go.
Before you guys head out, plaintiff has 14 minutes to close, just 14 and change, and defense has about 25 and change.
I will not be taking all that time. Oh, there you go.
Time checks. Works for me. Tech ready to roll over there? Ms. Gaskin, ready?
Yes, Your Honor.
Okay.
May it
When you're ready.
please the court. This is what the defendant told Grace Topping. New top speed, 50 miles per hour. What the defendant didn't tell Ms. Topping, what they didn't tell anyone, is that their ride wasn't designed for this new top speed. Never inspected at that new top speed. Wasn't safe at that new top speed. What the defendant didn't tell Ms. Topping is that that speed would kill her. When they made it faster, they made it fatal. That's why Ms. Topping's family has sued the defendant for her wrongful death. We had to prove to you that a design defect in that ride caused Ms. Topping's injuries. That's exactly what we did today. We met our burden by asking you to focus on 3 simple facts. Number 1, those lap bars had a maximum speed. The defendant ran it faster, and that speed killed Grace Topping. Let's walk through those one by one. Starting with the first, those lap bars had a maximum speed. This is undisputed. The defendant's lead engineer said those lap bars were designed to handle 45 miles per hour maximum. That doesn't come from an engineer that we called to the stand to tell you that. That comes from the person who designed the ride. The defendant ran it faster. We showed you those emails where the defendant said, let's bump it up to 50. And the first thing their engineer says is, yeah, that's a bad idea. You see, perhaps the most compelling evidence in this case that it was a design defect to run that ride at 50 miles per hour is the words of the person who designed the ride himself. Alex, not sure about that. Hydra's route wasn't designed with 50 in mind. I'm concerned about how that increased speed will affect those lap bars. Now, at this point, you may be wondering, well, 45 miles per hour versus 50 miles per hour, that doesn't seem like a big difference. Even the defense tried to tell you today that's a small difference. But this isn't about what a driver can handle when you're on the road going 45 and 50. This is about what a piece of machinery can handle. As Ms. Wax told you on the stand, a maximum engineering capacity. And to run a roller coaster faster than it was designed to handle, that's completely unsafe. The defense tried to tell you today, well, we inspected it before they bumped it up to 50. The defense tried to tell you, oh, we tested it. Yeah. For 4 minutes. Opposing counsel spent at least 7 minutes cross-examining Ms. Wax today about that roller coaster. They spent more time defending that roller coaster than actually testing it. In that 4 minutes of testing, it doesn't even prove to you that the ride was safe. Opposing counsel told you in opening statement that first test run, no problems, second test run, no problems, third test run, no problems. Fourth run, we give up. We're done. That's good enough. There were 14 seats on that ride. They needed to test all 14 of those individual lap bars to make sure they were safe. But what did they do? Did they put crash dummies in all 14 of those seats? No. Ask their employees to sit in all 14 of those seats? No. Ask their engineer to sit in all 14 of those seats under all 14 of those lap bars? No. They had one person in one seat under one lap bar. Members of the jury, think about why that's so important. I don't even know if Miss Topping's lap bar was ever tested. That brings me to my third fact. The speed killed Grace Topping. This is where we had a battle of the experts. Ms. Wax, she told you the speed killed Grace Topping. The defense expert said no, it was something else. So let's weigh their credibility. Ms. Wax, she makes her living on the ground designing roller coasters for Disney World. Their expert makes their living testifying on behalf of amusement parks and amusement parks only when they hurt people. And Ms. Wax, her conclusion makes sense. You heard it time and time again today. The faster the roller coaster goes, the more force is put on the lap bar, and the more likely it is that the hydraulic system will fail, that lap bar will come up. You know it was the speed. Because of how many times they ran that roller coaster safety at 35 miles per hour. For 6 months, every single day, all morning, all afternoon, 35 miles per hour, a lap bar never came up. Nobody ever got hurt. But the first day, they bump it up to 50. Grace Topping dies. When they made it faster, they made it fatal. Members of the jury, this is the verdict form. Let's go through it together, starting with the first question. Did we prove that a design defect in the defendant's ride caused Ms. Topping's death? Let's talk about what that means. A design defect happens when the risk of serious harm outweighs the burden on the manufacturer to make that ride safe. So what you have to ask yourself, is the risk of Ms. Topping dying, someone getting seriously hurt on the defendant's ride, does that risk outweigh the burden on the defendant to run their ride at that 35 miles per hour? You know there was no burden on the defendant to run that ride at 35 miles per hour because they did it before. For 6 months, they ran that ride at 35 miles per hour and it was fine. Nothing was wrong. But we also had to prove to causation that the design defect caused Ms. Topping's injuries. Members of the jury, the speed killed Ms. Topping. It's the reason why her lap bar came up. It's the reason why she died. So we'll ask that you check yes to question 1. Now the next question on this verdict form, the defense had the burden of proof. Did they prove to you that Ms. Topping's own negligence was a substantial factor in her death? Members of the jury, today, the defense has asked you to believe that Ms. Topping pressed her own emergency release button on the ride. There are 2 problems with that defense. Number 1, they can't prove it. They keep pointing to these text messages where a teenage girl is joking about something extreme with her best friend. Where's the evidence that she said, I'm going to press the button? Where is the evidence that after these text messages, she ever brought it up again? On the day of even, right before she's getting on the ride, yeah, I'm gonna press the button today. You don't have that evidence. Where's the evidence that she was even serious? Members of the jury, you gotta know. This is a serious accusation against Ms. Todd. That it's her fault that she died. It is one thing to text your friend something extreme. It's a complete other to be on that ride, feeling that speed, 150 feet in the air, upside down, knowing if you press the button on the side of your car, your lap bar will come up, you will fall, and you will die. Killing yourself. What the defense has asked you to believe, with no evidence that at 17 years old, she even wanted to die. Not to mention, nobody saw her do it. Nobody saw her reach towards that button. Nobody saw her press it. Nobody even saw her turn towards it. The second problem with that defense is it's not a defense. The defendant put a death button on a ride available to kids. It's not a defense because it's a design defect by itself. Their CEO took the stand today, admitted 150 feet in the air, upside down, the only thing keeping you in place is that lap bar, but yeah, I put a button there that would release it. Well, they tried to tell you, oh, it's required. No, it's not. Not within reach of passengers, it's not. Think about all of the other ways they could have done it. Put it under the car, behind the car, so they could be helped in case of an emergency. The ride operator could come over and help you out. They didn't do that. They put it within reach of kids. Don't forget, members of the jury, what you heard on Ms. Wax's direct examination. They tried to tell you over and over again, this is a safety feature, we need it. Those were the words of the CEO on the stand today, we need it. No other rides have it. So we ask that you mark an X to that second question on the verdict form, because they didn't meet their burden. Topping was only 17 when she fell 150 feet. She's just about to graduate. Now she won't. She'll never get to start a life.
Objection, Your Honor. As to this line of the closing argument is going into loss. This is bifurcated and it should not be touched on during this liability portion of the trial.
Overruled. You may continue.
She'll never get to start a life of her own or take her own kids to an amusement park one day. That's why we ask you find the defendant liable for her death. Because when they made it faster, they made it fatal. Thank you.
Thank you, Ms. Gaskins. Giacomo?
At the beginning of today's trial, my co-counsel told you the 3 ways that you would know today Hydra's wrath was not defective. It's when Dragonwald consulted with the experts about that ride. when they tested that ride and got consistent, successful results, and when that ride was compliant with all of the regulations. Members of the jury, it is those three reasons that you now know Hydra's Wrath was not defective. Not before July 6th, not during, and not after. But you see, the plaintiff, they brought this claim today and they had to prove to you two elements. That there was a design defect in Hydra's Wrath and that whatever that design defect was caused Ms. Topping's injuries. Now, please make no mistake about it. We have not come here today to tell you that what happened on July 6th was not devastating. It is horrible that the Toppings have had to sit here and relive this day. But you see, throughout trial, in trying to meet that burden, the plaintiff has thrown you theories. Theories that started one way and changed throughout trial, and still they can't meet their burden. They tell you from the very beginning, this lap bar can't handle this new max speed. Dragon World ran it at that speed, and that was the fatal speed that killed her. But then you suddenly hear about a button, and they tell you, well, that was the defect. Members of the jury, it's not enough for them to throw theories at you. It was their burden today to give you evidence and prove it. And you know they didn't. So let's talk about it. When you walk through these elements, when you go and deliberate that first question, whether there was a defect, your analysis can start where really this whole case started. This certificate that the plaintiff didn't really want you to pay attention to, but let's not forget, this was a certificate given by Klein County. Klein County, who looked at this same ride and looks at those lap bars, the same ride that looks at the ride's control system, knowing full well it has the ability to run up to 99 miles an hour. Members of the jury, we brought you this so you can look at it closely when you deliberate. Nowhere on this will you see a max speed that this couldn't exceed. Nowhere will you see on this that button location on the side of the car was unsafe. Nowhere will you see that there was a limit that this ride had to run under in order for those hydraulics to be safe. You're not going to see any of that here. And why you won't is because this ride was safe. It could run faster. Now, that's an important point that we have to talk about, putting this certification to the side. The plaintiff, they just came up here and they told you, no, we're only talking about 5 miles an hour. That's what we've argued to you all day. Members of the jury, we do need to put it in perspective. Because remember, this ride was running at 35 miles an hour when they were talking about all of those months and months that this ride was running perfectly fine. But don't let them try to confuse it for you. It was designed and tested from the very start to run 10 miles an hour faster than that. And then when they thought about increasing this speed, it was 5 miles an hour faster than what they already knew hydraulics could handle. But even put that to the side and put the fact that there is no speed limit on this ride to the side, think about what came after. You see, the plaintiff, they keep bringing up these concerns with this ride running at a faster speed. But think about what Alex Watson told you herself. She didn't dictate a speed increase. She didn't order anyone to do it. She consulted with the ride's builder, the engineer who built it themselves. And she said, what do you think? Members of the jury, we had to tell you what came after. The plaintiff never did. What came after were tests, consistent tests, where the same engineer who they wanted you to believe was so concerned about that extra 5 miles an hour on that lap bar said, you know what? I'll go on it. Strap me into the lap bars, put this to 50 and I'll test it myself. Not once, not twice. 4 different times we're testing these lap bars that can't handle hydraulics faster than 45 miles an hour. Members of the jury, it doesn't make sense They did handle speeds higher than 45 miles an hour because they could handle speeds higher than 45. But let's not forget. Now, on direct examination of their engineer, on cross-examination of ours, we keep hearing that Grace Topping's seat was not tested. Let's just get something straight, members of the jury. The judge is going to instruct you the claim that they've brought. It's a design defect. They are claiming that this ride was defective, not Miss Topping's lap bar, the ride itself. So besides running their own tests and getting consistent results, these engineers went ahead and tested their own and tested every single one of those lap bars. 10 different times they have the speed at 50 miles an hour. Every single one of those seats have a test dummy in it. They are putting weight on that restraint system. 140 different times these lap bars are tested, not a single lap bar releases. Not a single one before July 6th, not a single one on any other ride on July 6th besides Miss Topping's, and not a single one after. Members of the jury, this didn't come as a surprise to Dragon World. This is the result you have when you are compliant with every rule, industry standard, and regulation. Just think about this. You've heard today from the plaintiff that they had advertised this new max speed for a month, and that was what was bringing people into the park. You didn't hear anyone take the stand today and tell you someone from Klein County reached out during that month and said, wait a minute, I saw the speed that you're advertising. I haven't inspected that ride and we need to make sure it's safe. Or, hey, I happen to know that that ride's hydraulics can't handle that speed, or it needs different restraints. You need to change that. You didn't hear it today, members of the jury, because it's not the case. That ride could handle speeds up to 50 miles an hour because they did that day. Consultation, consistent test results, and compliance with all of the rules and regulations, that is how you know this ride wasn't defective. But you see, the plaintiff, they then tried to meet their burden today by putting an engineer on the stand and tell you their theory about what happened here. And at first they started telling you, no, the amount of force that a rider puts on that lap bar at that speed is going to be too much. It's going to release. But then they tell you that the button on the side is a death button, and that's what caused this to release. Which one is it? So fine, I did speak to Miss Wax, and I asked her to explain these theories about that button that she thought was so unsafe. Members of the jury, please don't let them confuse it for you. That is an emergency button that a rider needs in case of an emergency. And according to the plaintiff's theory, they want it outside of that car or under the car so that a rider can't use it. What if there's a fire? They're not supposed to use it according to them and only them, because industry standards and other rides that you learned about today have it in the exact same spot. But to them, that's a defect. Okay. So then we also talked about that speed that the hydraulics couldn't handle. And the only thing that Miss Wax told you about was the 50 miles an hour that ride was running at. She didn't tell you how weight was something you need to look at. So I asked her, how does it make sense if weight plays into force that Jared Hackcliffe at 190 pounds goes on that ride 4 different times, 50 miles an hour, and not a single time does his lap bar release? 55 more pounds, more amount of force than Miss Topping, and his lap bar never releases. She didn't have an explanation for you. And the reason why is because the hydraulics could handle that speed. Members of the jury, you know they didn't meet that first element, So they couldn't have met their second one either. The cause, we know it wasn't a defect. That's because the why here, as devastating as it is, it has nothing to do with a defect. You see, the plaintiff just stood here and posed to you that we want this to be the answer, that she went there that day. She wanted to hurt herself. No one has said that today other than the plaintiff. All we've shown you today is the evidence. They've conceded that evidence in order for a lap bar to release without any of these mechanical functions. The only other plausible explanation is that a rider hit that button. She made an error in judgment. Members of the jury, we're not telling you she wanted this result. So when you ask yourselves, what is more likely to have happened here? That a ride increased their speed 5 miles an hour more than it had been tested at the past, had a button on the side that Klein County never had an issue with. That was the reason this happened. One lap bar releases and it was missed toppings. Or on the other hand, this topic. We talked about this ride days before she ever went to that park. Talked about the button on the side of that ride. Imagine if you press the button on the side of Hydra, it would make it so much scarier. You know what's more likely, members of the jury? That's why her friend lied to the police about what happened. She didn't want her to get blamed. So when you get this verdict form in a little while, I know that plaintiff's counsel told you you could stop at the top, but that's not true. Oh, excuse me, it is true. You know that there was not a defect. You know that no defect was the cause of Ms. Topping's injuries, and then your job is done. But if you go through the rest of these questions, it's my job to show you why we proved our case. It's because we showed you what happened here, members of the jury. The facts, the evidence, the law, your common sense showed you what happened here. Ms. Topping, they've contributed to her injuries. Dragon World did what they were supposed to. They consulted. They had consistent results and they complied. Find Dragon World not liable.
Thank you, Mr. Giacomo. Plaintiff get rebuttal?
Opposing counsel told you consultation, consistent test results, and compliance proves that this ride wasn't defective. So let's take those one by one. Consultation. Who did they consult? They didn't have anybody inspect that ride at 50. Consistent test results. 4 test results. Where they didn't even test Ms. Topping's lap bar to make sure it was safe. Compliance. Compliance with what? You heard there was no regulation whatsoever about the placement of that button. This is common sense. You don't put a button within reach of children that can kill them at any point where there's a lack of judgment. We're not trying to have it both ways, members of the jury. The speed killed Ms. Topping, but even so, that button was a defect, so their defense isn't a defense. When they made it faster, they made it fatal. Find Dragon World liable. Thank you.
Thank you.
And then it's just the comments and we'll be able to Yes, for clarification, the definition of it, storage. That's not. It's the library. 109 is the plaintiff, 104.
Plaintiff was 109.
109, 104.
That's right.
Can I use any of these microphones? Matt and Veronica, I have yours. Aaron, no rush, but Aaron, Lorraine, Spencer, and Jim.
I'll rush him still.
I'll be here all day regardless. So take your time. Okay, thanks. Sometimes it takes a second. All right, all the ballots are in, so we're going to just hear some brief comments from our scoring judges. And then we'll get to the announcement of our 2022 national champions. I'll start with my colleague from Clyde Inspector, Lorraine Donnelly. You're first.
You guys did awesome, really, really great. It was really good to watch for us. I wrote comments for every part, so I'll just go through them really quickly. Plaintiff's opening, Mr. Jones, you had really good theme. Except in the beginning, when you called her a girl, I wrote to myself, humanize her from the beginning, say her age and her name. And then maybe I would have incorporated some corporate defendant is going to try to blame the victim. Don't let them get away with it, something like that. Defense opening, I said, good to say that the emergency relief button was industry required, but then it got me wondering if that was a defect too. Plaintiff didn't mention that in the opening, but I was like, oh, maybe that's going to be an issue. For plaintiff's direct of the friend, it was good bringing out the lie on direct, but then you didn't follow up with why. Like, why did you do that? To have her explain. The defense cross of the friend, I get that it's touchy because that's the friend and she lost her, but she did lie to the police and it's kind of a big deal. So I might have maybe would have harped on that a little bit more. On the plaintiff's direct of Jones, the expert, one of my questions I wrote was the expert ever able to recreate the bars lifting at 50 miles an hour? I felt like that was a big thing to harp on, that they were never able to recreate it. I would have just said that as many times as I could. And then I'm trying to skip to go quick. Oh, the plaintiff's cross of, I forget which witness it was. I think it was the owner of it was witness number one. So it was the owner of the amusement park. I thought you did great confronting her with the email and pointing out that the guy who designed it had concerns. I thought that was awesome. The fact that they didn't put dummies in each seat, like everything you did was great. And very good, the way that you like set up that when the passenger's upside down and 150 feet in the air, that like kids are in danger because of the placement of that button. It was just really excellent the way that you led up to it. The only thing I thought you missed was pointing out and harping on they could have had the state, an independent agency, do their own inspection and they chose not to. The closings were really excellent. Ms. Gascon, am I saying that right? Gascon, you did excellent. I mean, really, really amazing. I thought your delivery was great. You hit on all the points. When you called it a death button, I thought that was great. I just thought that was really good. And both sides did really great in the closing too. So I think it was just awesome. I hope some of that was helpful.
I echo that. You guys did a great job. Closings were very, very, very good. The only two things that I thought maybe could have been developed a little bit more from the defense side, maybe pointing out, especially with the friend that was on, that, you know, her lap bar didn't come up. No one else's lap bar, really touching on that. I thought the plaintiffs, you were talking about defense having it both ways, but I thought you guys were trying to have it both ways with the button. You made it seem like it was very easy for her to push, which goes against that there's no evidence that she pushed it. Nobody would have saw it because it was so easy. But I thought you guys did a phenomenal job. It was a great round, and I'm glad I got to see it.
I'm just going to give brief thoughts because I know you're not going to do this problem again. On the whole, I thought both sides had a coherent theme and that everything really hung together, which is really important to me. And it also seemed that it was strategic, that there was ground staked out for both sides, and you kind of defended the ground you were on, and to some extent went on your opponent's ground and tried to fight them a little bit there. I would have liked to see a bit more in the closings, taking on the other side's ground, other than sort of reserving it a little sandbaggy for the plaintiff's last time speaking. And I would have liked to seen it woven a little more coherently through the defense closing, rather than it be its own kind of like section. I would have rather sort of seen the clash of these two versions factually of what happened straight all the way through, rather than kind of like, this is my canned thing that I'm going to say about my case, and then here's my response to the other side. But on the whole, the handling of the issues was really well done. Two small things that I think are maybe a little more specific to this case, but just food for thought for future competitions. I would have liked a little bit of a factual preview for me throughout the plaintiff's case about this button. and the button being kind of an alternative theory. I get it that there's a strategic reason that you're waiting to use it against the affirmative defense that the defense is bringing, and that to some extent you're waiting to see how they structure their affirmative defense. So I get that you're not positing it as a defect in the opening, but I would have liked to factually hear that this button was here and where it was located. We were like almost 3/4 of the way through the trial before somebody pointed out to me on the photograph where the button would even be located. I can't see it in the photo, so I wouldn't have figured that out without the testimony. So I would have factually liked to know about this button a little bit earlier. That's a small sort of case specific thing. And in terms of the defense, I think the absence of facts sometimes are the best facts for the defense. Plaintiff has the burden of proof. All of the things the plaintiff couldn't show me, all of the things the plaintiff couldn't do, right? They control this roller coaster. They control the machine. Like, where's the evidence about how much hydraulic fluid was in this thing? Where's the evidence about how much people weighed who rode the ride before, right? Where's all this evidence? I'd like a little bit of that to come out through the witnesses. Sometimes the best cross is not oriented around the facts of the case, but the gaps in the facts when you're the party who doesn't have the burden, right? You know, it's mock trial. You don't control what the facts are, but you can do a really nice closing about the facts that you would expect a plaintiff to have that they didn't end up having because the problem doesn't give it to them. So sometimes the absence of facts are the best facts for the defense, I think.
Hi, thank you so much for having me. You can tell I took my coat off and rolled up my sleeves because I got excited about the case about halfway through. I've done this a lot as a coach, way back in the day as an advocate, later as a coach, and more recently as a frequent judge at a lot of these tournaments, and I've ran some of them. So I've seen a lot of rounds, and I can tell you that honestly, I was trying to think back to remember a round that I saw that was so evenly matched. Really, I struggled throughout to differentiate all of you, and that's the honest truth. And I've seen probably hundreds of these, so I'm hard pressed to find a more evenly matched final round. Outstanding job all around. I have copious notes, most of which I'm sure you're not interested in because you're not going to try this case again. I'll give one tiny critique that struck me, and it's about credibility as an advocate, credibility with your case, being consistent with your case. There were a few instances, I think on each side, where I thought, gee, I'm hearing this too late, or I'm hearing a position that sounds inconsistent with something you told me later. There was an objection at one point about the read-in, I think, right? And it didn't dawn on me until we were doing the defense read-in that I think it was the same read-in, right? I mean, it was a few lines later of the same read-in that you had, and it seemed to me a little, okay, well, if it's, you know, sort of goose and gander. If I'm going to read this, is the rest of it coming in, right? I mean, am I really honestly going to object to the very next line, which isn't all that different? So if I heard that wrong, or if it struck me as kind of, okay, let's remember our credibility. So I would just give that as an overarching critique to everybody. Remember your credibility as an advocate. Try to be consistent with your positions, and try to. I honestly, when I read the redaction too, because I could read through the black markings that you had, like I thought, well, the redaction isn't very good, but then I obviously read it and I was like, well, who cares about any of this? Like, why was that a big deal at all? So I mean, the redacted testimony didn't really help one side or the other, or the redacted text rather. So that kind of struck me. But anyway, outstanding job, great job.
Great job to all of you. Really enjoyed myself. I think both teams really brought it to the other side and made it, you know, really difficult for us to judge it, and also made the other side work a lot harder to get the win. Definitely, it's not an easy competition to judge, and whoever won definitely wasn't an easy W. I echo a lot of my fellow jurors' comments. I will say, Mr. Jones, when you called her, when you referred to the plaintiff as a girl, it was like the first thing that kind of like hit me. You have to humanize her. You know, she died a very tragic death. And I probably would have led with just a photo of her, opposed to starting with the defendant's conduct. I would have just introduced her to the jurors. and kind of pulled on those heartstrings. I know you guys aren't arguing damages or anything like that at this stage, but you got to make people care. And I think that that was an opportunity missed when you started off with the conduct. I also think that there was like, I feel like you guys could have done a better job, everybody, when it came to the facts of the testing. I was waiting to hear how much these dummies weighed, how much Miss Toppins weighed, how much the engineer weighed. Like, as I'm writing it down, like it didn't come out until, few witnesses later. It's like, oh, okay, all right. I feel like that probably could have been introduced a lot earlier, and it probably would have helped the jurors start. People are making up their minds as they're hearing this stuff. They're not really waiting to the end to start deciding. Like, people are picking sides as they hear things. So important things like that I feel like should have come out earlier. The plaintiff's friend who lied, I know you guys had to be a little like touchy with it because she witnessed her best friend's death. Obviously, you don't want to be like make her out to be like a monster. I feel like you could have hit her a little harder for the fact that she lied to police. But I still think that overall it was a great job. I think plaintiffs did a really, really great job at crossing defense's experts, especially the property owner, the CEO. I felt like you guys could have shot her a little bell on the defense side. There were a lot of asked and answered objections that I was waiting for. She was like really hammered on, whether or not there was some stuff about the restraint bars. I felt like she was asked like repeatedly, and it was just like, shoot her some bell, like throw an objection. But great job from the plaintiffs on pressing her on those issues. But you guys, you all did a great job. It's really good.
I've been a lawyer for almost 25 years. I've tried over 40 cases, and I'm not lying when I tell you that I've seldom seen the skill, smoothness, the intelligence that I saw here today. The preparedness that you put into this, the way that you deliver yourselves, the way that all the thought that you put into your presentations was quite impressive, particularly in your level of experience. So I just want to start by saying that it was very, very, very impressive. So, and on top of that, the way that we have to score this is not unfair to us, but it actually is unfair to us. So whoever comes out winning this, it's not like the team lost. It's just that we had to add up points. Somebody had to win it because it couldn't have been more evenly matched all the way around. In terms of I echo everything colleagues said here, but I just have some individual comments. Sydney, starting with you with regards to the death button, right? That's a tough argument to make. And everything I say to you guys, this is like very, 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 very subtle type points because we have to dig that deep because everything was so good. But it's really challenged with this death button thing. So in terms of strategy, and I know you're not going to try this case again, but maybe when any of you face a situation where my client is being accused of doing something that I don't think that they did, but assuming that they did do it, another reason why the defendant should be liable. I mean, that's an argument to make. And the challenge that you had was establishing the button was defective, but on the same token, not really that the your client would have done something in his mind mentally stupid at the release button while on a roller coaster. So my only advice being that if you're faced with that situation again in the future, try to incorporate in your arguments to remind the jury and remind the witnesses that, okay, the defense is saying she basically killed herself. So we don't buy into that. However, if one were to think that this is defective because of actual, you said all of that, but if you package it in a way where you're saying basically this thing with her pushing the button is BS, and I'm only going to say this because they're making me say it, because they're the ones making this accusation. But you made all of the arguments and you did all of the examination you needed to do. But if you package it in a different theme, it doesn't have the credibility issue talking out of both sides of your mouth, which I'm not accusing you of, but I can see that that's a struggle, not only for this fact pattern, but any fact pattern that gives you that kind of conflict. On the other hand, I don't want to be cross-examined by you, like ever. Yeah. Peter, great job. The one piece of advice I'd give you with regards to opening is put facts in your opening and not just nice facts about a client. But I would have wallpapered the courtroom with this email. I would have hit it first, hit it hard, and it would have been all over the place. And being a plaintiff's lawyer myself, of course, privacy is very, very important. And I think to me that email was instrumental to the plaintiff's case. And it's something that, pick that particular thing and you just want to hammer it. Anna, great job. The comment I have for you is with regards to Driscoll. One of the things that I would like to see, Driscoll's on the stand and she says, "Oh, I didn't see her push any button." Not saying that I think she pushed the button, but she's on a roller coaster. Who's attention to what the other person on a roller coaster is doing? So what I would like to have seen is like a cross exam, basically chewing her head off, going, "So you're telling me at a period of time from when this ride started, she fell out, you were observing everything that she's doing to be able to determine whether or not she reached over and pushed the button?" I mean, I would have liked to have made that particular point a little more. And I think that just goes to seeing the big picture. And then my one comment with regards to you is your cross-examination of wax, and experienced trial lawyers do this too. And we wish we didn't, is that there were a few points that you made and then you ask wax continually. So it's your still your opinion this is defective? Yeah, absolutely. My opinion, change my opinion. And the strategy is, I know what you're getting at. It's almost like a sarcastic, like, "Hey, I was so smart. I just showed you how you're wrong. And you still think that this product's defective." And the problem is with expert witnesses, it's like going into the casino, right? You can only go so far and they'll eventually get their money back. So you just want to you want to resist temptation to ask the extra question, because inevitably they'll shove it down your throat eventually. Again, to all of you, congratulations. Excellent job. Thank you again for all your hard work.
Okay, we announced the winner. I just want to say a couple of very, very first to our scoring judges one more time for being here. I want to just very quickly thank our witnesses. First, Allison Stevens, who's a 1L at the School of Law. Allison is a 1L in our Courtroom Scholars Program, which is a scholarship that we offer to undergraduate competitors who come to our law school to compete in our trial team. And we're excited to have her today, but we're even more excited to see her compete on the team next year. And they can't come next August, can't come soon enough to see Allison on the team competing. I also want to thank one last time, Deeksha Walia, our tournament director, was also with us. We did a fantastic job this weekend, and Deeksha, this would not have been a successful without your help. So we really appreciate it. And that, I want to thank Porter Sai, who's our extraordinaire. I think the wife probably wants to murder me, considering how much time he spent with this weekend, but he's done a great job with the photos and the live stream and everything. And so I really appreciate Porter's help. Now I want to introduce the scoring judges to the teams. For the plaintiff, we had team 109, which is the UCLA School of Law. For the defense, we had team 104, which is Stetson University School of Law. This was an incredible final round. I think probably our best final round yet. This 5th annual Battle of the Experts, the last 2 Battle of the Experts were won by UCLA, so they were going for the three-peat. These 2 teams actually met in round 4 of the preliminary rounds, and it was a very, very close round, a 2-1 decision. And this round was closer. It was a 3-2 decision. So a very, very, very razor thin margin. That, let's get to it. The 2022 Battle of the Experts national champion, still national champion UCLA. And just a round of applause for Stetson. They were fantastic. This was an amazing final round. Thank you everyone for watching. We'll see you next year.